All persons having business before the Honorable Chief Judge and Associate Judges now residing over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Right. Good morning, everyone, and welcome to the District of Columbia Court of Appeals. We are continuing at this time with our virtual remote oral arguments via Zoom, which are being live streamed for public access. This morning, we'll hear three cases, and the first case is Derek Watson versus United States. I see that appellant will be arguing along with amicus curiae. Could you let me know how you plan to divide the time this morning?
Yes, Your Honor. We are going to divide it in half, and Mr. Gonin is going first.
Okay. I'm joined this morning on the panel, as you can see, with Associate Judge Phyllis Thompson and Senior Judge John Fisher. Are you ready to proceed, Mr. Gonin?
Yes, Your Honor. With the court's permission, I'd like to reserve 2 minutes of my time for rebuttal.
Okay. So your time, I guess, just so we're clear, we're about 7 minutes, 7.5 minutes each. And of those 7 minutes, you want to try to reserve about 2 minutes.
Correct, Your Honor.
All righty. Thank you.
No problem. Good morning, and may it please the court. Daniel Gonin on behalf of amicus curiae. And the reason I'm going first is our plan was that I would focus on the legal standard for forfeiture of self-defense by provocation, and then Ms. Persico will address how that standard applies to the sufficiency of the evidence for both the provocation instruction and to defeat the MJOA. So the standard for self-defense is a purpose to provoke. Over a century and a quarter ago, the Supreme Court held unanimously in 2 different cases that a provocation instruction should not have been given where there was insufficient evidence of a purpose to provoke. As the government now concedes, those Supreme Court cases were binding precedents on the common law of self-defense as it applies in this jurisdiction at the time those cases were decided. And that's because Congress prescribed murder in a single federal statute, the Act of April 30th, 1790, that applied both in the District of Columbia and in the Indian Territory where Beard and Thompson, from which Beard and Thompson arose. Making things clearer, the Court of Appeals of the District of Columbia, the predecessor to the DC Circuit, held in Wallace, a 1901 case, that purpose to provoke was the standard, and that in that case, there was sufficient evidence of purpose to provoke. The 1901 code expressly preserved the common law as it was in force on March 3rd, 1901. Beard, Thompson, and Wallace.
Mr. Gonin, I understand your pedigree argument. It's in your brief, but help me with this. Beard and Wallace are written in a style that is quite different than the way we write opinions today. They are more descriptive than prescriptive, at least in my view. Do you think they translate seamlessly to the argument you're making as to what the law should be today?
I do, Your Honor. One point I think is worth emphasizing is that the rule of purposeful provocation is not some kind of aberration or anachronism. It is today still the overwhelming majority rule in most jurisdictions, and most of the treatises describe it as the correct rule. For example, we cite Professor Volok, who's written a lot about self-defense, and he says, from what I can tell, it's almost always specific purpose to provoke, except for Laney and a 1913 Arkansas decision that's been legislatively overruled. So I don't think it's odd to read Beard, Thompson, or Wallace as prescribing a purposeful provocation standard when all the other evidence would suggest that's exactly what they recognize the law to be, because that's what the law is almost everywhere.
You assert that this panel has the authority to overturn our recent precedent because the older law is in your favor. Do you think this panel is obliged to do that? Or is that something we could prudently leave for the en-banc court to address?
I believe the panel is compelled by binding precedent sort of on the law of precedent to follow the earlier controlling decisions despite the more recent decisions. And there's a couple of examples I think are pretty illustrative of the court's obligation to do that. One we cited in our brief is Gone v. Van Buren Street Church. The other one that I didn't cite in my brief but occurred to me more recently is Carroll, the decision on threats. And in Carroll, the court did go en banc, but at the division stage, the division reviewed the kind of two different strands of precedent on the mens rea for threats, and it recognized there was a case, Campbell, that came out in 1982 that said that it's intent to utter the words, and then there was a case, Bache, in 1983 that said it's intent to utter the words as a threat. And what they said is, our holding, I'm quoting from the division opinion in Carroll, our holding in Thomas v. United States, a case that we cite, compels us to follow Young, Gurley, Postel, and Campbell, the first one, all of which preceded Bache, even if the issue had not been resolved by a different case. So the division in Carroll was obligated to follow the earlier cases, and the court went en banc and then went with the Bache standard. So the earlier standard was wrong in the en banc court's view, and so they adopted the Bache standard. And then Gone v. Van Buren Street Church is, I think, 100% the same, where you have a 2010 decision of this court in a case called Sears that says you don't tack different periods of adverse possession. And then the court reaches back to a 1920 decision that kind of cryptically states some suggestion has been made that there's no tacking, but we think that's wrong, citing cases. I'm only paraphrasing that slightly. And this court said, we're bound to follow the 1920 decision, not the 2010 decision, even though, you know, we're basically saying our decision in 2010 was wrong. And, you know, two judges even on the panel even said, we think that the rule is bad policy, but we're bound to follow it. So I think.
Yes, I'm sorry to interject, but I see where you're going, and I take your point that you think that we are obligated to follow Laney, to sort of reach back over some of our more recent cases to follow Laney. And that's something that we will be exploring, I'm sure, further with our questions. But I wanted to ask, sort of bringing us forward to this case now, if you could walk me through why you think the jury instruction on provocation that was given in this case runs afoul of Laney. What is the language that is troubling, either that is there or that is not there, that makes it inconsistent with Laney if as you argue, we are obligated to follow Laney?
Sure. So just to clarify, I'm saying the court's obligated to follow Beard, Thompson, and Wallace over Laney. Although, you know, part of our argument is that you can read Laney as adopting or recognizing Beard's purposeful standard as the governing standard, because Laney does quote Beard and say, you know, we think, you know, if there was an intent to provoke a conflict, then a different rule would apply, which is correct, you know. So the problem with the instruction that's given in this case, and it is inconsistent with Laney because it omits a key word, but it says you can provoke violence if you have a reason to believe. You may not actually believe it, you may not want it, but if you have a reason, any reason to believe that your presence will provoke trouble, then you cannot claim self-defense. So it is, I think, would be construed by the jury as a negligence standard. You know, they may not think of it in terms of the word negligence, but they would certainly interpret it as saying, it doesn't matter if you didn't want violence. It doesn't matter if you tried to avoid violence. It doesn't matter if you didn't even think there was going to be violence. If you had a reason to believe that there would be trouble, you cannot claim self-defense. That would most naturally be understood by the jury as a negligence standard. And this court has said phrases like reason to believe or reason to know in other statutory contexts is negligence.
Yeah.
So negligence, yeah.
I'm sure we're going to get into it more on the facts of this case when either through you or through Ms. Persico. But, you know, this purposeful provocation language that you rely on, I guess I'm going to be curious as to why it doesn't apply to all three, Watson, Williams, and Salou, and sort of zero out the self-defense claim for any of them. If what you just said, if I track what your argument is, the way I would view it is that they all came with the purposeful intent, or because they were all armed and there for this interaction, confrontation, whatever you want to call it. But I know you're focusing us on the legal arguments, and I'm just trying to figure out, make sure I understand the instruction as you argue it should have been, and then I guess we'll grapple with how it relates to the evidence in this case.
Sure, and it looks like I might be out of time, but I don't want to step on Ms. Persico's toes, but I do want to say, look at the facts of Beard and Thompson, where the Supreme Court said there is not sufficient evidence of provocation. Those were people who armed themselves and went over to a place where they knew they were going to encounter people who had threatened to kill them, and that was held to be insufficient evidence of a purpose to provoke. And here, Mr. Watson was there all day. It's not like he left, went home, got a gun, and came back. He's there all day. The gun is either on him or in his car. It's been there.
Yeah, there is a point of the video photographic evidence where he does go back to his car to retrieve his gun. And then that is when that immediately precedes the incidents that are the subject of this appeal.
I think one thing that will require some careful parsing of the case law is the issue of to what extent the later cases, the post-Wallace, Thompson, Beard cases are developments in the law or expansions of the law as opposed to being in conflict with the earlier law. It's one thing to say, we hold today that if you provoked a quarrel and it's calculated to lead to homicide, or you come with the purpose of provoking difficulty so you can slay someone, you're not going to be able to avail yourself of self-defense. But that doesn't necessarily mean in other settings too, in other circumstances too, you won't be able to avail yourself of self-defense, such as if you come knowing that your presence is going to provoke trouble. So what do you point to establish the point, Mr. Gunn? And I guess is what I want to ask you, that Laney and later cases are in conflict with that, rather than sort of a development of the law or an expansion of this doctrine of provocation.
Well,
do you understand the question?
I absolutely do, Your Honor. And I do think Laney is a pretty clear, at least as it's interpreted, was a clear break with prior precedent. Because if to say that purpose is required, and in the absence of purpose, you don't give a provocation instruction, I think is inconsistent with saying, well, even in the absence of purpose, if you have some lower mens rea, that's just as good. That's not developing the law, that's changing the law, which can only be done, through certain means of, overruling prior precedent in a legitimate way. There are, I think, other recognized ways in which you can provoke violence. For example, if you're a robber and you rob someone and you threaten them with violence, but if they don't comply, you have no intention of harming them. But the act of robbing someone would, if they defend themselves from the robber, you can't then claim a right to use defensive force. That's another kind of recognized exception in the law. But that's certainly not what the theory was here. And if you apply I think the easiest way to think about this is take the reason to believe standard and apply it to the facts of, say, Thompson, where Mr. Thompson, it was undisputed that he felt threatened when he went by this field where he encountered these people who had threatened to kill them. And so before going home, he decided to go get a gun. And he went to a different house. He could have stayed at that house, presumably, until the man he was scared of had gone home and left the field. But no, he went to a house, he got a gun, he went back, and when he saw one of the other men walking over to a rifle, he turned and shot. And the Supreme Court said this was not a provocation case. And there are plenty of other Supreme Court cases that say arming yourself in anticipation of being attacked does not cause you to lose your right to self-defense. You only lose your right to self-defense if you arm yourself with the purpose of creating a pretext to take a human life. If you just think to yourself, I don't know what some people are capable of.
But Mr. Gonen, here we seem to have passed the point of people merely arming themselves, which makes this sequence of events troubling to me. Even if we were in agreement with the law as you laid it out, we're beyond people just arming themselves. We are at a point where guns are drawn and very quick reactions and responses. And shots are fired all around with Watson, Williams, and Mr. Salou. And so we don't just have I've got a gun in my purse or backpack and we're here at a barbecue. We've got guns out, drawn, raised, poised, and fired. And so even if we were in agreement with the legal framework that you've suggested, it seems I'm troubled that and I'm not sure I'm there on the legal argument, but I do take your point, and it's one that I think we've got to really carefully think through where we go on this. But I hope Ms. Persico, maybe perhaps at her argument, will show us how, even if that were the framework, why it applies to how the facts and sequence of events played out here.
I'm happy to speak to that, but if you want to turn to Ms. Persico, I don't want to step on her toes.
It's up to you all how you want to go, and we can give just a little bit of leeway in terms of time if you both want to respond to that briefly.
Sure. I mean, I'll respond to it very briefly. Elena Harris, who's one of the witnesses, she testifies that when Mr. Watson comes back from his car and is talking to Salou, he's trying to make peace. That's her testimony.
With a gun in his hand.
He doesn't have a gun in his hand. At least there's no evidence he has a gun in his hand. No witness testifies that he has a gun in his hand, and the video doesn't show that he has a gun in his hand. He obviously has a gun in his pocket or on him somewhere, but there's no evidence that he's got the gun out. And the government is
there was some photographic. I don't know if we're talking about the video or the slideshow or the photos and evidence that we have as part of the materials on appeal, that it appeared that there was a gun in his right hand. It wasn't drawn at the time he initially encountered Mr. Salou.
There's absolutely no evidence of that, Your Honor, and I would urge the court to look at the slideshow and the video carefully.
I did quite carefully, frame by frame, which is why I'm saying this. So if I'm, if there's other contradictory evidence, but it is on the slideshow, and I could, as I viewed it, but perhaps I missaw it or saw something that wasn't clear on the phone. So I'm sorry, Mr. Gonen, please proceed.
I do believe what the government's argument was, because you can't see on the video or the slideshow when he draws his gun, that he must have had it out the whole time. But I don't think they've actually pointed to a specific image where you can see a gun in his hand. And all the witnesses who are out there, none of them testify that they saw a gun. Mr. Watson has his arms at his side, and he is trying to make peace. I don't see how, Elena Harris's testimony that Watson is trying to make peace would be consistent with, him having a gun in his hand. So I think the gun is not in his hand. And you can clearly see the moment when Kevin Williams approaches him, and everybody agrees Kevin Williams has a gun in his hand, and everybody agrees Kevin Williams was planning to shoot Mr. Watson. And you can see him turn and react to that. And everything that happens from that moment when he turns is a reaction to when he turns around and sees a man with a gun in his hand approaching to shoot him. That's the moment when he's entitled to use defensive force. And I don't believe the government has even argued that they disproved the elements of self-defense in the absence of provocation. Their whole case lives or dies on the provocation theory. And if purpose was the standard, I'll just point out that the jury wasn't told that, and their verdict does not reflect a finding of purpose to kill. In fact, they acquit of of all of the assault with intent to kill charges.
All right, thank you, Mr. Gonan. And we'll reserve your time for rebuttal, and we'll hear from Ms. Persico now. Thank you.
Hi, good morning, Your Honors. Deborah Persico on behalf of the appellant Derek Watson. And like I said, I plan to focus on the facts dealing with self-defense, and I'll submit on the briefs for the other issues. So our position is that no matter what standard you apply, whether it's intent to provoke or whether it's a reason to believe that you're going to provoke trouble, whatever standard, the government failed to disprove self-defense beyond a reasonable doubt. I'd like to correct your impression of the facts. And the way I'd like to do that is to take you through 3 critical areas of evidence. And these areas are all linked together. They're all linked together, and you can't look at them in a vacuum. So the first one I'll talk about is what happened before Derek Watson went to his car. Then what happened when he returned from his car, and then what happened during the shooting incident. So first off, unlike Andrews, unlike Howard in those cases, there is no evidence whatsoever in this case of any prior violent or violence-threatening confrontations between Mr. Watson and Salou or Mr. Watson and Mr. Williams. Not before that night, not earlier that night, and not during that conversation with Mr. Salou before Mr. Watson went to his car. So the government is hanging its hat on Elena Harris's testimony. And all Elena Harris tells you, I'm sorry, are you speaking?
Sorry, I apologize. I'm on mute.
I saw your
That
lips.
happens a lot.
Okay.
I guess if you could help clarify what you say may have been my misimpression from the slideshow.
Mhm.
After Mr. Watson goes to his car, you see him walk between 2 cars around, he steps out of his car and appears to be putting something in his waistband or pocket area, steps around the cars, and that's when he walks up to Mr. Salou and they are speaking. His arms are at his side, right? And then Mr. Williams appears over his shoulder, and he turns and immediately raises the right arm, which was at his side, and from my viewing of the slideshow appeared to have his something in that hand. But that's the hand that when he turns, he raises, and it has a gun in it that he has pointed at and subsequently fires at Mr. Watson when he sees Mr. Watson with a raised hand with a gun in it as well. So walk me through where I may be
Okay, so
misapprehending.
first off, I think you're missing that there was an initial conversation between Mr. Watson and Salou before Mr. Watson walked to the car. That conversation is very important because Jamal Quigley testified that they were just having a casual conversation. Cheyenne Washington testified that they were talking as if they were normal people. And even Elena Harris testified. This is
I don't dispute that.
Point,
Yeah, I don't dispute that at all. And I saw that part of the
Mhm.
slideshow as well.
Okay, so I mean, well, you don't see them initially talking in there, but that's my point. You don't see them on film initially talking. We don't know where they were when they initially spoke, but the testimony is that there was an initial conversation and then Mr. Watson walked to his car. Now, look at the slides. You will see Mr. Watson walk to his car. How is he walking? With his back to Mr. Salou. Mr. Salou's on the sidewalk. Mr. Watson walks past him to his car, back to Mr. Salou. First question you have to ask, who would put his back to someone that he has reason to believe is going to shoot him? So
But are you suggesting, Ms. Persico, that when he gets to his car, Mr. Watson walks to his car, all that is captured on the video, just as you said, Are you disputing that when he opens the car door and then gets back out, that he did not move his hands to his waist area, that he did not put any object in his waist area, did not have any object that he had retrieved from the car? You disagree with that part
Okay.
of what
Okay,
I'm saying?
so we dispute that there's sufficient evidence to show that he went in the car, but even assuming he went in the car and got a gun, he comes out of the car and all you can see on that video is him touching his waistband. You can't see his face. You can't see what gestures he's making. And that's where this case is completely different from Bryant. In Bryant, there were witnesses who said they saw the defendant grab his waist like he's pump faking. They saw him mean mugging, and they interpreted that as a threat. There were no rival gangs in this incident. All you see on that, you look at the video, you cannot see his gestures, and all you can see is him touching his waist, and there's nothing else, not one witness who said they even saw him do that, or that they even saw his face, making threats. So then what does he do? Salou is still standing on the sidewalk a few yards away from Mr. Watson's car. Mr. Watson gets out of the car. He doesn't walk towards Mr. Salou. He walks away from Mr. Salou. He walks, like you said, in between the two cars, between 1343 parking spaces, 1343 and 1345. Those are shown on Government Exhibit 200B. He walks far away from Mr. Salou, back up to where his friends are hanging out. And what happens? The government admits that it wasn't Mr. Watson who approached Mr. Salou. Mr. Salou stepped up to approach Mr. Watson at that point. And also look, that when Mr. Watson went in his car, watch what Mr. Williams and Mr. Salou are doing. They're communicating with each other. And Williams gives Salou a signal, like a thumbs up, like he's ready to go. And Williams moves back to the gate and waits for Watson to come up from the car. And,
I was going to ask you, Ms. Persico, what the evidence was that Salou and Williams came looking to shoot Watson. Is that your answer? What you just gave?
No, and also the government, and this was introduced into evidence, at Salou and Williams' sentencing, the government told the jurors, and this came into evidence, that they were armed, they came there purposely armed, ready to get revenge on Mr. Watson. That's why they were there, and that they tried to distract Mr. Watson.
Did the jury in this case hear evidence to that effect, or hear?
Yes,
what did they hear?
The defense introduced that portion of the sentencing transcript where the government told the court at Salou's and Mr. Williams' sentencing, and it's in my brief, it's spelled out. I believe it's in Mr. Gonan's brief, but I know it is in my briefs.
I'm sure it is. There's just a lot there, which I promise you we read, but
I know, and that's why I want to try to take you through it in smaller pieces so that you get the correct line of what happened here.
And then let me just interrupt one more moment to ask you whether you disagree with Chief Judge Blackburn-Rigsby when she says she saw on the video something in Mr. Watson's hand after he went to the car, because I thought I did too. What's your response to that?
So you can't see anything as he gets out of the car and walks toward the sidewalk where Salou approaches him. Now, and the government even admits, it's in the briefs, the government admits that they have no idea when Mr. Watson drew his gun. It is not clear on the video, it's not clear on the slides, and the government admits that they don't know exactly when Mr. Watson drew his gun.
Well, but on the video, Ms. Persico, when Mr. Watson sees Mr. Williams over his, I believe it was his right shoulder, and turns.
Mhm.
At that point, Mr. Watson has a gun, right?
Okay, but let me back you up again a couple seconds.
No, if you could just
So-
answer that part of the question.
Well,
He
yeah,
has
well,
in a
well-
matter of a second or two,
Mhm.
and I think this is at frame 591 on this sequence of videos. And he goes from his right hand at his side, he turns his head and he turns around. And he raises his right hand, and there is an object in his hand, which subsequently he fires. And
Well, you're
so
not-
we're not
sorry.
talking about hours or talking about seconds. And so that's why but I don't mean to get you hung up on this one point, but that is the basis for what I saw as I
Okay.
just.
Okay, so what happens is Watson walks up, Salou approaches him. Watson has his back to Mr. Williams. Again, ask yourself, who would put his back to a guy he thinks is about to shoot him? This is why we say there was no reason for him to believe he was going to provoke trouble. So then what happens? Look at the video. Don't only look at Watson, watch Williams. What Williams does is he shakes somebody's hand as Watson's coming up and Salou approaches him. And then he backs off, he puts his hand in his pocket, he pulls out his gun, a little girl grabs Williams' arm, he shakes her off, holds his gun at his side, and a second later, right at, I will find the time for you that he does that. Look around 8:53:56, and then you will, and continue from there. And what do you see? Williams does a little hop skip toward Watson, whose back is toward him. Watson senses that and whips around. And at that moment, Mr. Watson reasoned that any jury could find that Mr. Watson at that moment reasonably believed he was in imminent danger of death or serious bodily harm. It was that moment that he had the right to defend himself. When he was talking to Salou, he doesn't point his gun. Nobody says.
So he has a gun when at that moment, when you say he had the right to defend himself after he whipped around, which is what I guess my sequence is the same as the sequence you described, but maybe we're attributing different things to it.
Yeah, I think you're missing though, the whole picture. I think you're missing, like I said, the first part of this, where you have no evidence in this record of any prior violence, no prior violence threatening confrontations. You have to keep that in mind, because that starts to lay the groundwork for what Mr. Watson could reasonably believe, or what could provoke him, what would provoke him. He
Ms.
obviously-
Persico,
Yes.
you're a much younger person than I am, but you probably know that for decades in this jurisdiction, crap games have led to violence. And the evidence seems to be that Mr. Salou left in an angry mood, and before long he comes back with Williams. Why doesn't that give Mr. Watson a reason to expect violence and to prepare himself to meet it?
Well, there's a difference between expecting violence and thinking, this guy's a real hothead. I'm going to protect myself just in case he does something stupid. You can't equate that with the standard for self-defense. That does not equate to a reason to believe that your presence is going to provoke trouble. It doesn't equate to an intent to provoke merely because he might think this guy's a hothead. Because again, when you hear the witness's testimony about the tenor of the conversation, and also Here's what tells you that Mr. Watson did not have a reason to believe that these guys were going to shoot him. Elena Harris, Jamal Quigley, Cheyenne Washington, all sat there and they overheard the same conversation. But what did they do? Nothing. They just sat there, continued hanging out. They did not at all think that those conversations indicated potential violence. They didn't.
Ms. Persico, as I think it was Judge Thompson said, there's an awful lot in the briefs. So I apologize if your brief answers this.
Okay.
Do you go so far as to say that no provocation instruction should have been given, even assuming that this instruction was legally correct?
Right.
Your position is that no instruction on provocation should have been given on these facts.
Right. The defense counsel objected to giving the provocation instruction, and our position is, like what I've been telling you, there's absolutely no evidence in this record that if you follow this the way I'm asking you to, through the slides, through the videos, and combining it with the witness testimony, there was no evidence that he had a reason to believe that his presence would provoke trouble, and no evidence that he intended to provoke trouble under whatever standard you were going to apply.
Let's talk about when, which is important.
Okay.
Let's assume that you're right, that during the first conversation with Selu, he didn't have a reason to think, but something prompted him to go to his car.
Mm-hmm.
And I understand the government's position to be approximately, he should have closed the door to the car and driven away. Instead, he grabs a gun, maybe, maybe not, and then comes back. What about that precise moment? Did he put himself in a position where he knew his presence would cause trouble?
No. For all the reasons I just said, and the other thing is that the government has retreat, the doctrine of retreat, all wrong. Mr. Watson had no reason at that point that he went to his car to think that he was going to provoke a shooting or that intended to provoke a shooting. And there, at that point, he was
But if you assume,
an imminent threat.
if you assume it is proper to infer, as the government urges, that he went to the car and at that point got a gun,
Mm-hmm.
why doesn't he have reason to think that his continued presence is going to provoke trouble? He's preparing for it.
Because just the mere fact that he wanted to protect himself just in case Selu got a little crazy, that does not fit under the law for reason to believe you're going to provoke a shooting or an intent to provoke a shooting. And at the moment, it doesn't equate to that. The cases do not, all of the cases, look at Thompson and Beard, they do not allow for, I mean, they do allow for someone to prepare to defend himself, even though he doesn't think anything's going to happen, but I'm just going to be careful about this. That's all that this record shows. And what the government's asking you to do is to make an inference that's barred by Dawkins. So Watson goes to his car. The moment he goes to his car, he's not in any imminent danger of threat or of bodily harm or death. He's not in danger at that moment. He has no duty to retreat under the law.
Let me ask you this, Ms. Persico, as long as we're focusing on the when, as Judge Fisher did. So I believe what I saw in the video is the first part of what you've been describing, which is he's in his car, he comes out, we know he has a gun eventually, whether it was in his hand or his pocket, whatever, he had one.
Right.
But then at some point he goes back to his car to get something, additional ammunition or something
Oh,
it's
oh.
described as.
Mhm.
And I know there's argument in the briefs about how, well, maybe had he, instead of getting more ammunition, had he just gotten in the car and driven away, maybe he would have put himself in more danger. Who knows? But let's set that aside for a moment and talk a little bit about how we should regard his going back to the car, getting more bullets and coming back again. I don't know. My focus on the when is that I don't know whether any shooting that he did after that, and I think he did some, whether that's the basis for any of the charges or not, or whether all of the charges were based on what happened in the initial skirmish. What can you tell me about that?
Okay, so this is where Mr. Salou comes in. All right, Watson turns, Williams fires at him, Watson fires back at Williams, Williams runs through the gate and out of the picture. While Watson, watch the video, while Watson and Williams are shooting at each other, Mr. Salou, go back, look at the slides too. Mr. Salou is running around the side of the tarped car, right where Jamal Quigley is standing. He's running around the side of that car, around to the back of that car, and in between the two cars in spaces 1341 and 1343. And what happens as Williams runs out of the picture? Watson runs between the two cars between 1345 and 1347, the parking spaces. And when he reaches the back of those cars, Salou is at the back of the other car and Salou fires at him. There is a flash on the video. Detective Gargak said he saw the flash. And if you look at slide 723, you will see the flash yourself. So Salou fired at Mr. Watson, and then Salou hightails it back up to the sidewalk. Watson sees it's time for, he has time to get out of there. So he runs toward his car. He hides at the furthest place behind his passenger door.
Ms. Persico,
Okay.
Again, another question on the when of things. Is there any dispute that Williams, Watson, and Salou fire shots? Okay, and so what is your understanding? My understanding is that, what is your understanding of the sequence in which each of them fires their guns? And just tell me who fired first, who fired second, who fired third. Yes.
Okay, Williams fires first. He fires directly at Watson. He keeps firing. Watson fires back. As soon as Williams runs out of the picture, Watson is running down the car. Salou fires at Watson. Watson does not fire back. So Mr. Watson runs around the passenger side of the car while Salou's running up back toward the gate. Salou then fires again at Mr. Watson, who's crouched down behind the passenger side of his car. He fires several times. It's on the video. Mr. Watson does not fire back. Then
So
Mr.
according to
Watson,
you, Mr. Watson fires one shot only in this whole thing? Is that what you?
No, I'm not sure. Okay, and I apologize. I don't know exactly, but all of his shots are fired directly at Williams. That's it. He does not fire at Salou. And the government has this concocted theory that because there's seconds missing from the video, that, maybe he could have fired at Salou during those few seconds. You can't make it. That is not a reasonable inference. I mean, aliens could have come down during those 7 seconds and, lifted a kid up with them. You don't have any evidence of what happened during those seconds. And the government admits that there's nothing on video showing that Mr. Watson fired back at Mr. Salou. And our position is that any of the witnesses who said, they were all firing back and forth, they're mistaken about between Salou and Watson. Only Salou fired at Watson. Watson never fired back at Salou. Does that answer your question about the, okay.
Thank you.
Do you have any further questions?
All
I have a
right.
question, and I don't know which of you to direct my question to, but here it
Okay.
is. Let's just assume for the moment, there are a lot of arguments back and forth about this, but let's assume for the moment that the urban gun battle instruction should not have been given. Let's say it was erroneous. But there was evidence that would have allowed the jury to believe that Mr. Watson set off this whole chain of events, and therefore, under some theory, was responsible for what happened to the infant who got shot. JW, I think was his name. What was, and we see in both briefs, your briefs and the amicus briefs, that, well, you know, this wouldn't be aiding and abetting if Williams shot the child, because obviously Mr. Watson didn't share his purpose. And if the urban gun battle theory doesn't support liability, that wouldn't get you there. And, you know, I guess what I'm trying to get to is there a vicarious liability theory that would have allowed the jury to hold Mr. Watson responsible for what happened, for the injury to the child? And I guess one answer might be, well, there might be a theory, but the jury wasn't instructed on it. I suppose that's one answer. But I can tell you that if, and this is a big if, because I understand you dispute this, if Mr. Watson set off this whole chain of events, it's not a satisfying outcome that he's not liable, criminally liable, for what happened to the child. What do you want to tell me about that? Should I just conclude, well, you know, too bad in that circumstance, because none of these other theories fits and they weren't instructed on anything else, so he's just not criminally liable? Maybe that's the answer, but what would you say the answer is?
Well, I would say he's not criminally liable under an urban gun battle theory at all. He's not criminally liable. He was not the but-for cause of JW's injuries. And the government keeps making the argument that, well, you know, he kicked this off, and that, excuse me, 1 second here. And that if he hadn't been there, nothing would have happened. But that's not true. And we know that because the government admits at the sentencing hearing that it was Salou and Watson who came to the area with armed and with the intent to get revenge on Mr. Watson. So they are, or Williams is the but-for cause of Jay White's injuries. And if Mr. Gonin wants to jump in here, I'm happy to let him add to that. Or not.
Well, I don't know as a matter of procedure whether he can, so I'm just going to turn it back over to the chief.
Okay.
Thank you.
Oh, I can't hear you.
Thank you, Ms. Persico,
Sure.
and we'll reserve some time for your rebuttal. We'll hear from the government at this time, and then there'll be opportunities for both you and Mr. Gonin to have your rebuttal argument.
Thank you.
Thank you, Your Honor. Good morning, and may it please the court. Brian Hahn for Appellee, the United States. The convictions against appellant for assault with a dangerous weapon against Williams and Salou, the felony assault while armed, or ASBI while armed, against JW, as well as the associated firearms convictions, should be affirmed. I think I want to start with sort of going over the facts of this case. I think that the court and Ms. Persico have gone back and forth a little bit over what exactly happened. And so I just wanted to put forth, at least in terms of the provocation argument in this case, you know, appellant is only arguing that there was insufficient evidence to disprove self-defense and is insufficient evidence for the provocation instruction. So I wanted to lay out the facts as the government sees them that sufficiently support that instruction and the defeat of self-defense in this case. So, of course, we first have testimony about an argument between Salou and between appellant, where they're arguing, they're, quote, standing face to face. That's Geraldine Quigley's testimony about this first argument from the July 16th transcript 236. And then from the same day at 188, Jamal Quigley testifies that it's an argument between the two about some money. And there's some intimation that appellant is accusing Salou of cheating. And then, of course, Salou is angry. He leaves and he comes back with Williams. And then there's a second argument between the two. And this is from Elena Harris's testimony, the July 17th transcript at 109. They at first are, quote, letting each other know that we can be friends, end quote. But then, quote, but if you don't obtain what I am saying and take it the way I'm saying it to you, then it could go another way, end quote. And so, that sort of implies that if they don't sort of come to some sort of agreement with one another, there's going to be negative consequences. And then Harris continues to say, this is from 109 to 110, that Salou, quote, kept on edging on whatever happened, end quote. And when after Salou does the thing that she calls edging or escalating the fight, appellant goes to his car. And that's when he comes back. And that's when the shooting happens. Now, in terms of the slides, I know the courts looked at them. I know the parties have looked at them many, many times. But just to go through what happens after appellant leaves his car. So he's in his car, sitting there for, I think it's described in the trial as between 7 and 9 seconds. I think I counted at 9 seconds in the video. But at slides, after he leaves his car and comes around the two cars that are parked perpendicular to the sidewalk, this is slides 487 to 521. Appellant does that gesture with his waistband that Chief Judge Blackburn-Rigsby has been talking about. And as the government argued in closing, this was sort of analogous to, I don't think that we use the word pump faking at trial, but analogous to him sort of brandishing or showing that he has the weapon there. And then at slides 585 to 623, appellant walks between the two cars parked perpendicular to the sidewalk, steps up onto the sidewalk, Salou steps up to meet him. And at this point, it's the government's contention, of course, that the gun's already in his hand. Because from this point, where you can see his arm and his hand after he passes between the two cars parked on the sidewalk, perpendicular to the sidewalk. And all the way from there to the point where he shoots at Williams, or at least you can see the gun when he points it at Williams.
Can I stop you right there for 1 second, Mr. Hahn?
Yes,
I focus you on frame 591, I believe it is, which is the frame after which Mr. Salou has stepped up onto the sidewalk to meet with Mr. Watson after he's come between the cars. I think it's about frame 591, where his right hand is at his side. And as I've said, it appeared to me that there was a gun, and that is what you said the government's contention is. Because I had understood Ms. Persico to say that the government essentially conceded, maybe that's too strong a word, that there was no gun in his hand, or that no one saw the gun in his hand. And that was making me start to think I might have been seeing things on the video, but it just could be that there were no witnesses at the scene that specifically testified. Was this the government's contention, or do you base it on some of the evidence that was admitted and that was actually before the jury?
So Ms. Frisco is correct that there's no witness that testifies when appellant draws his firearm, but the government bases the contention that maybe I'm misspeaking here. But one, I think you're right, Your Honor, that you can see a gun in his hand, or at least you can reasonably infer that there's by looking at it, there's an object in his hand, that it's the gun. And then, of course, you can also, I think the only reasonable inference from seeing his hand the entire time from slide 591 and a couple slides back, in fact, once his hand comes into view, the only inference is that he has the gun in his hand because he never draws anything in between there and the time he points the gun at Williams and then fires. You'd expect to see on the video that he would put his hand in his waistband or in his pocket or somewhere to get the gun from if he needed to draw it, but he doesn't. And so, again, the only reasonable inference there is that he's got the gun in his hand, and then you can, I think it's difficult to see. I think it's not as clear that just looking at slide 591, like definitely there's a gun in his hand. But given the circumstances surrounding what happens next, I think that the only reasonable inference, again, is the gun is in his hand. So at that point, yes,
Mr. Hahn, in civil cases, we sometimes talk about comparative negligence. Let me ask you about comparative provocation.
Sure.
If anybody came to this area intending to provoke violence, it seems to me that it was Selu and Williams. There's a pretty good inference that Selu went off angry. He got his buddy Williams. They both came back armed to confront Watson. If those are fair inferences, why should Watson be disqualified from exercising self-defense when they're the ones who came to him looking for trouble?
So I think that this is Chief Judge Blackburn-Rigsby's concern earlier, that she said that it seems that everybody here, Watson, Selu, and Williams, have all forfeited their right to self-defense because of the provoking actions they took in this case. And so I think that if Williams, and even if Williams and Selu came with the intent to provoke violence with appellant, if appellant also, putting aside the standard for now, but if appellant also returned from his car with his firearm out by his side to also provoke violence, then he has also forfeited his right to self-defense. I don't think it's the same as the comparative negligence standard in terms of tort law, because I think that when we're assigning liability,
it's probably a bad analogy, but am I right that the essence of your argument is when he went to the car, he should have kept going, and it's his decision to get back out of the car with a gun in his hand that forfeits his right to self-defense?
that's certainly one of the points here, or the main point. I think that even, I don't sort of know about difficult hypotheticals here, but let's say he stays in the car and doesn't go anywhere. He just sits in the car. I think then it'd be hard to argue that, or at least harder to argue that he provokes violence if it ensues after that. But that's not what happened in this case. He gets out of his car, armed, approaches Selu on the sidewalk there. And then just to sort of finish out my sort of discussion of the slides, at 6:23 to 27, while appellant is facing Selu, he then turns to look at Williams. He raises his arm and points his gun at Williams. That's slide 627 to 635. He then takes a step towards Williams. That's slide 636 to 649. And it's only after that Williams raises his arm. That's slide 653. And of course, the government, the video shows that Williams fires first. That's slide 654. But as the government argued in closing in this case, just because Williams had the faster draw, or for whatever reason was more willing to pull the trigger, that doesn't mean that appellant didn't provoke that action from Williams, or intend to provoke trouble, or have reason to believe that he would have provoked trouble. So moving back to the standard, I think the government's position is sort of the inverse of appellants here, that no matter what the standard is for provocation, whether it requires an intent to provoke violence, or as Laney says, a reason to believe that your presence would cause trouble, that the evidence is sufficient in this case for a provocation instruction in the first instance, and then to defeat self-defense under a sufficiency of the evidence standard.
That then brings us to Mr. Gonen's argument. The instruction was bogus So even if there was a support for it, there was legal error by giving this particular instruction.
And Your Honor, I think there's a reason why it's amicus that's raising this argument instead of appellant. And I think the government argued in its brief that the court shouldn't reach out to decide this issue because appellant isn't arguing that the instruction itself was error. And I think that's because if appellant did so, appellant did not object to the language of the instruction. And therefore, we would be reviewing that claim for plain error. And under a plain error standard, of course, we have decades of precedent going back to Laney, which explained that this standard is the correct standard. So, Laney, of course, the DC Circuit case from 1923 that we've been talking about. There's a case called Roe from 1966 in the DC Circuit that quotes Laney and says that self-defense may not be claimed by one who deliberately places himself in a position where he has reason to believe his presence would provoke trouble. And then, of course, Mitchell from 1979, case from this court, quotes Roe that where he has reason to believe language. That case is quoted by Howard in 1995. Of course, there's Sams, which says that the intent to provoke is not and has never been the law of the District of Columbia when it comes to provocation, all the way to Andrews in 2015, which quotes a case called Tyler, which is in turn quoting Laney, which says if one has to
clarify for me, what is the government's position about the impact of Beard and Thompson and I think Wallace?
So there's a couple things. I think that in terms of Beard, Thompson, and Wallace, first that I think as Judge Thompson was talking about earlier, that the DC courts are allowed to interpret the common law and develop the common law as different situations occur in front of the court. And I think that that's exactly what happens in Laney and in subsequent decisions after that. These cases are just interpreting the law and adapting the common law to the situations that come before it. And this is sort of a different issue in terms of the gun battle instruction, but as cases like Roy and Bryant recognize, DC is the only jurisdiction in the country that is entirely a city, and that there might be some special considerations that come from that because getting into shootouts or gun battles or provoking violence in a mostly urban environment has a higher risk of harm to innocent bystanders. But I think the second point here also is that even if Laney is a misinterpretation of Beard and Thompson and Wallace, the rule in Oregon that amicus talks about is one where the prior precedent is either ignored or not cited, not discussed by the intervening precedent. And here we have Laney, which directly quotes Beard, which directly cites, which believes that is using Beard as some sort of authority, whether or not it's controlling or persuasive. And here, therefore, looks like we lost Chief Judge Blackburn-Rigsby. There we go. Here, therefore,
Well, I was hearing a lot of feedback and trying to mute myself, and I inadvertently turned myself off the camera. So sorry about that.
No, it's no problem. It's no problem. But here, that then ends up that appellant's argument, amicus's argument, is just that Laney should be overturned, which, of course, a panel of this court is obliged not to do. That can only be done through an en banc court. And so the government's position is, go ahead.
No, go ahead.
The government's position, is going to sum up, is that the instruction given was proper, and that is the law of the District of Columbia when it comes to provocation.
I wanted to ask you, Mr. Hahn, about the urban gun battle theory and also the concurrent intent theory. And the jury was instructed on both. So I guess with respect to the urban gun battle theory, does our intervening decision in Fleming impact, well, it was harm, I assume you would concede. Is it a reversible harm? And I assume you contend that it wasn't. Could you tell us why it wasn't in light of Fleming?
Yeah, so So Fleming didn't sort of disavow all of the gun battle causation type causation, right? What Fleming says is that you both need a close connection to the injury that's caused. So that's the proximate causation that was subject of the instruction that was given in this case and pre-Fleming instructions. Fleming says what you also need is actual cause or but-for cause. And what Fleming does is pull from, it's either Burrage or Barrage, I'm not sure how that's pronounced, but says that, you know, if you take the defendant's actions out of the chain of events, would the injury have happened? So in this case, when we're talking about the crimes, the convictions that don't merge, this is the assault with a dangerous weapon against Williams and Salou, and then the assault with significant bodily injury against JW. The absence of a requirement from an instruction that says the jury must find but for causation was harmless. And so I'll first talk about Williams, for example. You know, the video clearly shows appellant is directly firing at Williams. And so there's no need to use this idea of gun battle causation to say that appellant committed an assault with a dangerous weapon against Williams. Because again,
let me ask you about the little boy.
Sure.
It seems to me that there's a philosophical debate, maybe it's a metaphysical debate, about what the but-for cause of his injury is. And the government seems to have conceded that it was Williams who fired the bullet that struck JW. In the absence of an instruction explaining to the jury what but-for causation means, how could they reasonably conclude that Watson was the but-for cause of JW's injury?
Yeah, so I'll point the court to, this is Fleming at page 226. It says, to illustrate the point concretely, we hold that a defendant can be viewed as having personally caused death if and so we can adapt this to injury in this case. So cause injury if the defendant shoots at another person or takes action such as bringing an armed group in search of another person or brandishing a gun at another person, to the defendant's acts foreseeably cause the intended target or another person to fire shots in response.
I want to distinguish here between what the law would permit and what the fact finders were told about evaluating the evidence that they heard. They weren't told the essence of what you just quoted from Fleming, were they?
No, but I think that the evidence was so strong in this case that this is exactly what happened, that the jury, there's no reason the jury would have found otherwise. That had they been given the correct instruction, as Fleming now teaches us what the correct instruction is, that the jury would have found appellant guilty of the assault with a significant bodily injury anyway. Because again, I don't want to repeat myself in terms of the facts of this case, but appellant, leaves the situation. And I'll point out that when he turns his back, as Ms. Pershko says, on Salou and Williams, they don't shoot at him then. So, but he turns his back on them, walks to his car, sits in his car for 7 to 9 seconds. Then he comes back with a gun, and then he kicks off the whole thing by confronting Salou with a gun in his hand, by turning and pointing it at Williams, triggering the shot from Williams. And so, I think that means that that evidence proves that he is the but-for cause of the shot that hits JW.
You're saying that on these facts, the only way the jury could have found that Mr. Watson was a substantial factor in causing the child's injury was a reason that would have been equivalent to but for. Is that kind of what you're suggesting?
That's correct, Your Honor.
I mean, if you tried to describe how he was a substantial factor, you might end up saying, but for his coming back with the gun, none of this would have happened, I suppose.
That puts it a little bit more eloquently than I did, Your Honor.
I don't think that's eloquent at
More
all, but
succinct.
I'm just trying to understand your point.
Yeah, I think that is the government's point here, Your Honor, that absent appellant's actions, JW would not have been injured, and there's no contrary evidence. There's no evidence.
Mr. Hahn, could you also
I'm
address?
sure-
Oh, I'm sorry, Judge Thompson. Go ahead. You had a
Well,
follow-up.
I was just going to
question.
say, I know you addressed this in your brief. I'm trying to recall what your point was, anticipating the argument that the urban gun battle theory applies only in a homicide situation and not to injury. What did you say about that? Or did
Yeah,
you
so-
say
so
something about that? I think you did.
The brief did say something about that, Your Honor, and that was that just that what Fleming describes is causation, and but-for causation and proximate causation, and those are things that are not limited to homicide cases. So, for example, the Supreme Court case that Fleming bases its analysis on, which is Burrage or Barrage, talks about whether or not I think it's under the Federal Controlled Substances Act, whether or not death or serious bodily injury resulted from the defendant's distribution of a controlled substance. That's a sentencing enhancement. And Burrage applies proximate and actual cause principles to that as well in terms of causing serious bodily injury. And so I think that, it's sort of illogical to say that, well, you can cause death in this way during a gun battle, but you can't cause any of the other injuries that happen. The person has to die first before you've caused them. And so if the gun battle instruction or theory is just a principle of causation, then it should apply any time that injury is caused.
So the jury was instructed not to apply the theory to the intent to frighten assault charges. Is that correct? Am I correct about that?
No, so the jury was instructed to not apply the concurrent intent instruction.
Oh, the concurrent,
To the
that's right,
intent to
that's
frighten.
right. All right, thank you.
So there's a lot of different floating instructions here. If
So the jury had the ability, was left with permission to apply the urban gun battle theory to intent to frighten assault. And
yes,
that does not entail injury. And is your argument that allowing them to do that was harmless? Was that the point you made in your brief?
yes, Your Honor, and it's because the evidence is overwhelming or very strong that appellant directed his assaultive actions against Williams and Salou, and so there was no way the gun battle theory of causation is a way of attributing injury to a defendant who, in most cases, it's his or her opponents that have caused the injury. And there's no evidence in this case that Williams and Salou were somehow shooting at each other, and then the jury would have been able to attribute any crimes by Williams or Salou shooting at each other to appellant. And so those convictions, the erroneous gun battle instruction was harmful.
Let me ask you to speak to the convictions where what I'll call bystanders were the victims. I think there were 2 adults and a little child. I had the impression from your brief that they testified that they were literally standing between the combatants. And when Watson fired at Williams and Williams fired at Watson, they were literally caught in the middle. From looking at the video, I don't see that to be true. They appear to be off to the side and would not have been in the direct line of fire from Watson or Williams. So why is Watson liable for the assaults upon them?
So I think that I just want to parse the question a little bit, because I think the court doesn't need to decide any of that, because of course the all of the assaults with a dangerous weapon, intent to frighten, again are against Salou, and then the bystanders, all of those merge, and so the court doesn't need to decide that. But in terms of the concurrent, and I think we're going a little bit into the concurrent intent instruction, but I think that when independent of that instruction, assault with a dangerous weapon with the intent to frighten requires, the elements of that offense, that the defendant does an act that is, intended to frighten people, and the person has the apparent ability or intended to, frighten people because of injury, and has the apparent ability to cause injury. And so I think that when somebody does something like fires a gun in the air, brandishes a weapon, some sort of a non-specific threat with a gun. So it's not that I'm pointing the gun at you, but I am brandishing it. I think that all the people who are reasonably threatened by that action, that person, or at least that the person reasonably foresees, are threatened by that action. That person has committed assault with a dangerous weapon against all of them.
So you
I'm not
touched
sure if I
on,
answered your question, but
Not really.
okay.
you began
So-
to touch
so-
a little bit on the concurrent intent in part of your response to Judge Fisher, and I wondered if you could elaborate on the current intent instruction and why that was appropriately given or not in this case.
Yeah, so the concurrent intent instruction, of course, at a point at which the assaults with intent to kill are still in the case, intent is very much something the jury needed to consider. And as Judge Fisher said, Jamal Quigley testifies that appellants, it's not appellant and Williams shooting at each other that he's in the crossfire of. It's appellant and Salou. And so he says that he can't go anywhere because Salou is in front of him, appellant's behind him, and they're shooting at each other. And I think that was at least sufficient evidence for the instruction to say that at least those two were in the zone of danger from appellant's shots. And I would point the court to, JW does have two injuries. One of them, the bullet goes through and through. The other one, there's a 38 caliber fragment that is recovered from the thigh of JW by the doctor. And so that's why we're reasonably sure that Williams is the one that hit JW at least one of the times, is because based on the ballistics evidence, he's the one that's wielding the 38 caliber firearm. But we don't know what caliber the other bullet is. And while we think it might be more likely that Williams also hit the child a second time, that the evidence certainly was sufficient for the concurrent intent instruction here, and was sufficient to find that, for the jury to find that appellant hit JW when he's shooting at Salou.
All right.
Thank you.
Yes.
For affirm the convictions that do not work.
All right. Thank you, Mr. Hahn. Mr. Gonen, we reserved a couple minutes, I believe 2 minutes for rebuttal for you.
Yes, Your Honor. I just want to address one point Mr. Hahn made, which, as he acknowledges, Laney quotes Beard's language about a purpose to provoke. And I heard Mr. Hahn arguing that helps the government, but it doesn't. It hurts the government. It shows, number one, that Laney viewed Beard as controlling precedent, and number two, that Laney doesn't say, we think that's wrong, or we think a different standard should apply. It says, we think the same standard should apply. And in fact, Beard implies that if Beard had gone out to provoke an affray, a different rule would apply. That is the correct standard. So Laney, our view is that Laney should be read as consistent with Beard, and all this other language that's thrown in where it's talking about knowledge and every reason to believe is essentially a gloss on the Beard standard and imprecise, loose language that then gets picked up by the Red Book Committee. But it certainly could not modify the Supreme Court rule, and to the extent it created a lower standard, that's not, developing the law. That's overruling Beard.
What about Mr. Hahn's point that the substance of the instruction has to be reviewed under the plain error standard?
Sure. So again, I understand the plain error is in theory a difficult standard to surmount, but not in this case. If the court recognizes that purpose is the standard and the instruction is error, it's now clear because in Michael Thomas, this court said you can make
it's so clear and obvious that these particular cases have not been cited to us for decades, even though people have attacked the Laney instruction.
Well, that was kind of the complaint that Judge Ruiz made in her dissent in Gone, which is, we shouldn't read this Brumbaugh decision from 100 years ago as being such a clear holding when in fact nobody cited it. Even in the appeal before us, nobody had cited it. The court found it itself. And that was the dissenting view. So, the fact that it hasn't been cited, the Red Book is the Red Book. A lot of people aren't going to take that as binding gospel on what the law is. And so it kind of flew beneath the radar, I think, for a long time. The other thing I wanted to address very briefly is, the government cited Roe, the 1966 DC Circuit opinion, which does have a quote from Laney, but then it says, appellant cites numerous cases which hold that a defendant may claim self-defense if he arms himself in order to proceed upon his normal activity, even if he realizes that danger may await him. However, we think that the jury could have found that the course of action defended here followed was for an unlawful purpose. So Roe is sort of recognizing that there is this purpose standard out there and saying the purpose standard was satisfied in that case. And the DC Circuit's clear decision says the exact same thing. So the DC Circuit is saying, we're not convinced that this reason to believe is the correct standard, but in these two cases, we're finding sufficient evidence of a purpose to provoke. I do want to clear up a couple of factual issues, again, hoping I don't step on Ms. Persico's toes. The government has made a lot throughout this case about the fact that Watson goes back to his car. I think it's important to note that Watson is in and out of his car all night. You can see just on the video at 8:24 and 55 seconds, and then again at 8 hours, 40 minutes, 41 seconds, he's going into his car. So he's in and out of his car all night. So you can't really spin this nefarious take on that he went back there to get ready for a shootout. Number two, when you see him come out of his car, I heard Chief Judge Blackburn-Rigsby say it looks like he's stuffing something in his pants. As we argue, maybe it's his car keys, right? He just got out of his car. Maybe it's his phone. Maybe he's adjusting his waistband. Maybe he's stuffing a gun in his pants, but you cannot infer that beyond a reasonable doubt. And I would say the notion that he is stuffing a gun into his waistband is obviously inconsistent with the notion that he has it already in his hand. The other thing is he does not approach Salou. Salou approaches him and he kind of turns and then goes up to him, which I think makes this a lot like Tibbs, where Tibbs had armed himself expecting the possibility of violence. And then when his friend is beckoned into this courtyard, he goes with him and he says, the reason I went with him is to make sure he was all right. And that when the other people drew their guns, he pulled out his gun and fired first. And this court held, even under the reason to believe standard, that did not satisfy provocation because he responded, he went over to talk to someone who had called to his friend. And here Watson is going over to Salou, who's approaching him. And then, there was a lot of focus on the fact that Watson has a gun on him. And I think it's just important to remember that if Watson didn't have a gun on him, we wouldn't be here because he'd be dead. So the fact that he has a gun is what allows him to exercise his right to self-defense. I also think an important thing about this case, which I think sets it apart from any other case applying the Laney instruction, as Judge Fisher alluded to, this is not a case where Derek Watson went out of his way to look for trouble. This is a case where trouble came looking for him. And the question before this court is, what does the law require someone like Mr. Watson to do in this situation he found himself? The government argued to the jury that he had to get in his car and leave. And you saw later on in the video, you see Salou shooting directly into Derek Watson's car. So he's not exactly in a position of safety at that point. And the argument that he had to leave runs flat into Dawkins, which says you don't have to retreat until there's a justification to use deadly force. You do not have to pre-retreat from every possible interpersonal conflict. I respectfully, I want to address slide number 591. I've blown it up on my screen. I do not see a gun in his hand at all. I heard Mr. Hahn concede it's not clear, and under the reasonable doubt standard, I don't think you can infer that he has a gun in his hand at that point.
Do you think it's fair to say he has something in his hand?
No, I don't believe you can see his hand at that moment. I know there's light that appears to me to be reflecting off the car that's directly behind him, which is a dark colored car. It's a dark, blurry video, and it's been blown up in the PowerPoints. I don't think you can see his hand, let alone what's in it. And that's true later on when he turns to see Kevin Williams. I also think it's important to realize at the point he turns to see Kevin Williams is assaulting him with a deadly weapon at that moment. I point to COSAR of the United States, 144, 8th, 3rd, 27, which says just standing with a knife is assault with a deadly weapon, even if you're not, even if you're 9 steps away or something. So when he turns and sees Kevin Williams coming at him with a gun, he's been assaulted with a deadly weapon and can take defensive measures. The government says we don't know. He must have had his gun the whole time because you don't see when he draws it. But I just point to, I think it's around, starting at slide 635, if you go forward, there's like a dozen or so slides where you can't see his hand at all. It's in front of his pants, which are dark colored. It's a dark video. You can't see his hand. So that is a moment when he could be drawing the gun that he had in his pocket. And at that point, the government concedes. Williams raises his arm first. Williams fires first. And Derek Watson is entitled under the law of self-defense to respond to that by raising his arm and returning fire. And that if that's not self-defense, then I think, it's going to be very hard for anyone to claim self-defense, because the mere fact that you arm yourself, so you have the weapon with which to defend yourself, is going to be used against you to say, well, you knew that you were going to be attacked, and so, but because you armed yourself, and that just can't be the law. And then I do one other thing on the video. I think Ms. Persico was addressing this, but just to make sure it's crystal clear, the 7-second gap on the video happens after Salou and Williams have left. They've gone. You can see at 12 minutes, 39 seconds, you can see Salou running past the fence by house number 1341. He's gone. They're gone. They're both gone at that point. So at that point, there is a 7-second gap on the video. But no one claims that Salou and Williams ran back and re-engaged in the gun battle. And at that point, the bystanders are already gone anyway. So there's no point on the video at which Mr. Watson could have ever possibly fired in the direction of those bystanders. You can see the entire gun battle on the video. There's no missing portion of the shooting itself. So unless the court has any further questions, we submit that the court should reverse the convictions.
All right, thank you, Mr. Gonan. And Ms. Persico, you have 2 minutes of rebuttal as well.
Okay, thank you very much, Your Honor. I just want to address a couple other factual points that Mr. Hahn addressed. So he spoke about first of all, if you look at the government's brief on page 5, there's absolutely nothing in that brief that suggests that Mr. Williams had a gun on him when he approached Mr. Salou. Not that he didn't have a gun, but that there's no evidence that anyone saw a gun at that point. And if you look on page 5, the government says, Salou stepped up to meet appellant when appellant reached the sidewalk. As Salou and appellant faced each other, Williams was standing on the sidewalk several feet away. After facing Salou, appellant turned toward Williams. Now, the government doesn't say that when Mr. Salou and Mr. Watson were speaking, that anybody could see a gun. So that's right in the government's brief. Another thing is that on page 44 of the government's brief, after having said earlier that Mr. Salou was the one who stepped up to confront Mr. Watson, now on page 44, they're saying that Mr. Watson stepped up to confront Mr. Salou. So it can't be both. And if you look on the video, they were right the first time when they said that Mr. Watson was not even heading toward Mr. Salou, and Mr. Salou stepped up to approach him. And the reason for that is, if you look at the video, he had already communicated and Williams had given him the signal that everything was in place. They were ready to take on Watson. So that's one point. And as far as this whole gesturing thing, again, like Mr. Gonin has said and I've said, that video, I'm sorry, but that video is so fuzzy. You cannot possibly see what he's doing with his pants. So he's in the car, he gets out, he adjusts his pants. You cannot see a gun in that video. And you can't base a reasonable inference on anything from that video. And even more importantly, this, again, look at the Bryant. This is not like Bryant, where they had witnesses who could actually say, I saw him do this to his pants. I felt threatened by it. It looked like he was threatening. We don't have any of that. All the government has is some fuzzy video where you really can't see anything. Lastly, on this urban gun battle issue, you know, the government's argument on that but for is that if it weren't for Mr. Watson, you know, none of this would have happened. Well, that's just not true. And again, I'm going to direct you to what they said at the sentencing, and it's on page 2 to 3 of the appellant's initial brief. And what the government told the judge at Williams and Salou's sentencing. Defendant Salou went to great lengths to leave angry from his verbal altercation with Watson and find another person to join him. Together, they came armed and ready to get their revenge on defendant Watson. Most importantly, he and defendant Williams each came armed with firearms. While defendant Salou distracted defendant Watson, defendant Williams stood nearby with his arm by his side, ready to fire. Given the angle of and position of Mr. Williams and the baby who was shot, it is more likely that Williams' gun shot JW. Most importantly, he and defendant Salou came each armed with firearms looking for trouble. If you removed Mr. Watson from this, there still would have been a shooting. Mr. Watson was not the one who provoked the shooting. Salou and Williams came there ready to get their revenge.
But no way, if Watson hadn't shown up, there wouldn't have been a shooting, I assume. There's been nobody to shoot at, right?
Yeah, Watson hadn't shown up, of course, but Watson is there. Right. Had he done nothing, had he just stood there, they were ready to shoot him. And that's exactly what the government told the judge in Salou's and Williams' sentencing. So we are going to ask again the court to find that the government failed to disprove self-defense by a reasonable doubt and to reverse all of Mr. Watson's convictions.
All right.
Thank you.
Thank you, Ms. Persico. And
not his felon in possession conviction, though, right? You're not asking us to reverse the.
I misspoke. Yes, exactly.
All right. Thank you. We'd like to thank all counsel and Mikas for your briefs and arguments in this case. Very interesting issues presented before the court, and we will take the matter under advisement. Thank you all. And you can feel free at this time to exit our virtual courtroom. We'll prepare for the case.
Thank you, Your Honor.
Thank you, Your Honor. All right, good morning. This is the second case before the court today. Edward Holloway, personal representative of the estate of Rosetta Holloway versus Santos Carrasco et al. Are the parties ready to proceed today?
Good morning, I'm ready. Wait, are you?
I'm sorry, Mr. Merkel, I was having some difficulty hearing you. Would you mind repeating that, please?
I essentially just said, here I am. Can you hear me? And this is, I don't know what I can do to make it any more effective other than to maybe
I can hear
speak
you
closer to my phone.
much more clearly now. All right, Mr. Merkel, would you like to reserve any time for rebuttal?
Yes, I think I've set this up, depending on Your Honor's questioning, for about 4 or 5 minutes of reserved time.
All righty.
Maybe if the rest of us mute ourselves, the echo will go away.
Yeah, there's quite a bit of feedback, so we're going to mute ourselves. If you could just state your name for the record, Mr. Merkel, and then you can proceed. And as I understand you, you want to reserve 4 minutes for rebuttal. Is that correct?
That would be my intention, Your Honor, but of course it's subject to the court's questioning.
All right, thank you.
Good morning, Chief Judge Blackburn-Risby and Judges Thompson and Fisher. I am Patrick Merkel. I represent the personal representative of the estate of Rosetta Holloway, and that's Edward Holloway. Mr. Holloway seeks to recover for his mother's family, which is different from his father's family, its lost interest in 5200 Queens Stroll Place, Southeast. The property is noteworthy for its location in Marshall Heights, the poorest section of Washington, D.C., located inside the Southern Avenue boundary of the district, south of East Capitol Street.
Mr. Merkel,
yes,
I've
good
read
morning,
all
Judge
that
Fisher.
in your brief. I've read all that in your brief and didn't find it particularly helpful. At least speaking for myself, I'd like you to address the grounds on which Judge Campbell ruled against your client.
I can do that very well, Your Honor. Essentially, what Judge Campbell did was say that latches came into play. He cited a number of reasons why, all of which are invalid. The charging of notice to my client was at the heart of the Superior Court's award of summary judgment. But really, the notice was buried in considering whether Edward Holloway really should have known that his mother's interest in the property survived her death.
I'm sorry, Mr. Merkel, as I understand it, Mr. Holloway, Edward Jr., received a notice that he was entitled to a portion of the share of the proceeds from the sale of her property, which he accepted. And there is some evidence as part of the summary judgment motions, which was unopposed by any opposing statement of facts, that Mr. Edward Jr. was aware of his mother's ownership of the property based on efforts she made to maintain and pay for some of the expenses of the property.
Well, yes, that would have been during her lifetime. And the question that is glossed over is how Mr. Holloway should have known that her interest was not inherited by his father when she predeceased him. And Mr. Holloway did indeed have a sense, a very real sense of his mother's interest in the property during her lifetime. But what we can't avoid is the fact that the the deed was written in such a way that even the plaintiff's attorneys in this case tried to transfer it as a deed for tenancy by the entireties. 3 times in their complaint and 2 amended complaints, they referred to this as a deed where the parties intended a tenancy by the entireties. That is simply not law. That doesn't work.
But that's the heart of the matter from my point of view, Mr. Merkel. A litigant is generally charged with notice of anything that his lawyer knows. And you seem to be making the argument here that the lawyers got it wrong. But why is that something we should take into account?
Easily. Oh,
they had the papers in front of them. They could research the law just as you can and we can. And they didn't raise this issue in a timely fashion.
well, this goes to the point that lawyers are just like regular people when it comes to relying on other lawyers doing their job correctly. We believe they are following the law. We have to rely on them, especially when it comes to understanding the arcane nature of title work. Okay. This is like a cottage industry within the property rights field. This case points up what happens in a real estate transaction, especially when you're settling an estate. You've got 2 levels of legal expertise involved.
But why isn't Mr. Holloway's complaint with his lawyer and not with Mr. Carrasco or with Judge Campbell?
His complaint is with the title attorney, who knew full and well that what he was doing was taking a legal shortcut with the deed of conveyance and creating a bad deed in 2012, which was essentially nothing more than a quitclaim deed on behalf of the estate of Eddie Holloway, excuse me.
Was Mr. Holloway a beneficiary of the title insurance policy?
No. The buyer would have been the beneficiary of the title insurance policy. However, the title insurer, I'm sorry, the title attorney is the traffic cop that everybody is relying on here. Everyone trusts that they're going to do their job right. They're acting really in the role of a trustee. They take the property, they draft a deed, and the buyer gets title insurance that they're getting a valid deed, and the seller trusts that the deed was done correctly. But I can tell you, you can tell that District Title knew there was a defect here. And you can tell because there are no words indicating that Rosetta Holloway predeceased Edward Holloway in that 2012 deed. That would have been further implication that he had inherited from her by operation of law. But the fact that they didn't insert that language tells me, as something of a title expert, that they knew they were working with a deed that was not tenancy by the entireties, and they glossed over it because to solve the problems in this case in 2012 on a $60,000 sale would have significantly impaired the value of that sale. It's that simple. And then the next 2 title attorneys that handled this case were both Fidelity title insurance agent. And for them to raise the red flag about the 2012 deed would have been to raise a red flag against their own employer. It wasn't until it fell out of the title insurance mode with Fidelity that this issue was spotted by another title expert. But I think we need to understand these are issues that are easily overseen. When you see a deed for Edward Holloway and Rosetta Holloway, his wife, even a lawyer automatically jumps to the idea that this is a tenancy by the entireties, and it takes that extra level of understanding that I pointed out to plaintiff's counsel in this case, that the statute doesn't allow equitable estates as tenancy by the entirety. It's a statutory regime, and if you don't comply with the statute and name the estate of the grantees, they don't own it as anything but tenants in common. Now, I don't think that kind of expertise is something that you could ask Eli Gitterman, who's just monitoring the estate for the purpose of distribution, or even Joyce Alford's lawyer, her lawyer representing the estate, to understand these nuances. This is.
So help me, Mr. Merkel.
A lot of unfortunate things happened here, Mr. Merkel, to be sure. But how do those things overcome the application of the doctrine of laches? We have an interest in finality, and that's an important interest, just like property rights are an important interest. And the fact that some unfortunate things happened isn't enough to defeat it. How do you get around laches? Where's the error in application of that doctrine here?
Laches applies when you know. Otherwise, there's a statute of limitations of 15 years, which applies whether you know or not. So laches would be, you sat on your rights knowingly. That's not what happened here. Edward Holloway did not know that his mother's interest had survived her death and was not inherited by his father. And under the language of the deed, it was nuanced enough that it would take an expert in title law to understand that this didn't happen. There was still a surviving tenancy in common in the estate of Rosetta Holloway.
You seem to insist that Holloway had to have personal knowledge and understanding of the law. And why isn't he charged with constructive knowledge? Because he was both the personal representative of his mother and an heir of his father. He was represented by lawyers in both proceedings. Why isn't constructive knowledge enough?
Because you have to ask, what was the knowledge that you are going to charge his lawyer to have? I understand that you say that the lawyers could have researched it. I understand that you say that they could have looked up the law. But I don't think it's reasonable to ask them to do that, excepting in a context where there is an uncertainty. And when you hire a title company to do the job, you expect that title company to do the job correctly. And when they issue a deed, which to the people in that estate sounded right, because they knew that Rosetta had predeceased Mr. Holloway. But then when you or I might read that deed 10 years later, and we're seeing that the estate is conveying out an asset that its decedent acquired in tenancy in common with the person identified as his wife, but it doesn't say that his wife predeceased him, so that there's no inclination to believe that, unless you were one of the people who was really aware of that fact, you wouldn't jump to that conclusion that this was something where the personal representative of the estate of Eddie Holloway actually had the whole fee. You had everyone in that context believing that that was correct. Everyone, I'll add, excepting for Steve Sushner, the president of the district title, who wrote that deed. And like I say, I read that deed very differently. It is a bad deed. It is a deed of a quitclaim. And the fact that nobody has looked at the deed is really...
In some sense, Mr. Merkel, you're patting yourself on the back too often. You seem to be saying that until the 15-year statute elapses, Or if you come along before 15 years are up, then the transaction is not final. It doesn't matter how many times this house has been sold and resold. When you come along with your superior expertise, you can upset the whole transaction.
I wasn't the one that came along to upset the whole transaction, Your Honor. That was done by the attorneys for Wells Fargo when Carrasco was going to get some refinancing, and they went outside the fidelity title work. That's when, you had a succession of fidelity title agents who blessed the original 2012 deed, because to undo that deed would have caused a can of worms. So here came Wells Fargo, and they did. That's when we became aware of what the situation really was. And it's not me patting myself on the back. It's me responding to the fact that somebody has already opened up the door here and said, what's going on? Shed some light on the situation.
How does it matter, if at all, that your client has not joined any title company or any of the lawyers that represented him in this litigation?
I don't think it was appropriate for him to sue a lawyer based on malpractice. I don't think there was any question that the standard of care in the District of Columbia was met in what Eli Gitterman did to represent Edward Holloway, represent the now deceased brothers Tyrone and Gary and Greg Holloway. He had all four Holloways there, and they were looking for advanced distributions from their father's estate, and that's essentially what he worked out. As for his representation of the estate of Rosetta Holloway, that was for the work that he did with respect of the 5100 Drake Place property, which Eddie Holloway had acquired, I think in 1980.
Mhm.
So what I'm feeling is that we didn't need to join the title insurance company or title insurance agents. The title insurance company is the one behind Carrasco, and all we need to do is get a claim that there are damages to be paid, and the insurance company will pay them.
Mr. Merkel, I guess if I could, I'd like to take you back to the whole legal question of estoppel and latches. Are you arguing that, or do you concede that the only is it your position that the only prong of the latches argument that fails is that Mr. Eddie Jr. did not have knowledge? And if so, does that mean you concede the other elements that he accepted the benefits of the sale of the proceeds of the property, and the other element that Mr. Carrasco would be prejudiced by Mr. Holloway's delay in trying to assert his right?
I don't believe that it's necessary to address all of the elements of latches once you find that the actual knowledge has failed. Also, Mr. Holloway was never receiving any money from the state of his father as personal representative of his mother's estate. That would have set off alarm bells as to why am I getting money on my mother here?
Well, but he got money from the sale of his mother's property. He got a 1/5 interest, as I understand the facts here. Isn't that correct?
What he received was a 1/5 interest as the beneficiary of his father's will, but he did not receive any money from the sale of that property designated for the co-owner, the estate of Rosetta Holloway. So there's $60,000 reduced to $53,000 by the time there's distributable funds, and each of the 5 beneficiaries under the late Eddie Holloway's will received 1/5 of that. What would have happened if it had been done correctly and would have set off alarm bells, which Mr. Holloway then could have stepped up and protested the sale altogether for such a lousy price, which was half of the appraised value. You know, whether or not the property had been subject to being torched by you know, mentally ill family member, still was more than $60,000 in most people's view of what the property was worth. But it was under the control of the personal representative of the Eddie Holloway estate. Had that been under the joint control of the Eddie Holloway estate and the Rosetta Holloway estate, chances are we would have been either spending money on litigation to determine the legitimacy of the sale and how to determine the allocation of the money, or it simply would have gone back to the drawing boards and sat for another 5 years before it was figured out to sell the property. So yes, Mr. Holloway took his interest in the house as an heir of his father, but he did not recover for his mother's interest in the house. And there's another beneficiary of his mother's estate who's completely frozen out of these proceeds.
Mr. Merkel, the section of your brief that's headed "Latches simply can't apply when the claimant has no knowledge of his rights" cites no case law. What case law do you rely on?
Latches is an equitable doctrine.
Yes, it is. But what case law do you rely on for this point that it can't apply when claimant has no knowledge of his rights? It is an equitable doctrine. And usually, you know, when someone invokes that principle, it's because the party on the other side has done him wrong, has done some misdeed, and is, you know, won't be allowed to claim latches to escape the effects of it. But that's not what we're about here. There were, as I say, a lot of unfortunate things that happened, and people didn't do their work, etc. But we don't have the party on the other side who did something grievous to your client. And I want to know what case law you rely on for the point that latches can't apply when the claimant has no knowledge of his rights.
It's the very essence of the doctrine of latches requires that now that there is a knowledge of beforehand and that you are sitting on your rights. That is, since it is really an issue that the case law points to as a requirement, not as an issue that in the opposite mode for it not to apply. That was not something that I pursued very hard for case law. It just seemed that would be a sort of black letter a priori understanding that if Mr. Holloway, by his affidavit and by understanding the nuances of title law, the personal representative, as a personal representative, he simply didn't know, and he wasn't informed, and he couldn't have been informed by the people who were involved with this thing, excepting for district title, that his mother's estate still had the interest in common. And if you don't have that knowledge, then I don't think that any of the rules relating to latches are going to apply. You've got to have that knowledge that your mother's, in this case, he should have known for the doctrine to apply that his mother's estate had a surviving interest after her death and that his father didn't inherit her share, which is exactly how everybody, including the 2012 deed, either thought or implied.
All right, thank you, Mr. Merkel. We'll still allow you a few minutes for rebuttal. At this time, we'd like to hear from attorney for the appellees.
Thank you, Your Honor. May it please the court. Good morning. My name is Brad Bernstein. I represent the appellees, Santos Carrasco and Wells Fargo Bank. Your Honors all seem to be aware of the facts of this case. And so really the issue on this appeal is whether the trial court correctly granted my client's motion for summary judgment and denied the cross motion for summary judgment filed by the appellant. The trial court correctly decided these motions for three separate and distinct reasons. So as a result, if this court agrees with any of the three reasons, the decision of the trial court must be affirmed. The first reason that summary judgment was appropriate was based on the total failure of the appellant to timely and properly address the assertions of fact that were set forth in the motion for summary judgment. As a result, the trial court, as set forth in Superior Court Rule 56, treated the facts as undisputed. And those undisputed facts established that my clients were entitled to summary judgment. And for that reason, the decision of the trial court must be affirmed. Now, on appeal, the appellant fails to address this issue, and he failed to address it today. He failed to address the trial court's determination that the appellant failed to file a proper and timely response to the motion for summary judgment. In their brief, the appellant states that the timing of this case came during a time that his counsel had certain health issues, but the appellant also acknowledges that he remained largely silent about those issues without requesting much of an accommodation of the deadlines. That being said, the record reflects in this matter that the appellant did obtain an extension of time to respond to the motion for summary judgment, but still failed to comply with the DC rules. As there's no challenge to the trial court's initial basis for judgment in favor of my clients, the decision of the trial court must be affirmed. The second reason the trial court granted judgment in my client's favor was because the appellant's attempt to assert many years later, after the property had changed hands 3 separate times, for the appellant to assert a 1/2 interest in the property was barred by the doctrine of laches.
Mr. Bernstein, could I stop you here just briefly to make sure I'm understanding? In this motion for summary judgment that you filed, or that was filed on behalf of appellees, they attached a lot of documentation, including a statement of material facts not in dispute. No counter statement of material facts not in dispute was filed by appellants in the matter before the trial judge. Am I correct about that?
That's correct, Your Honor.
And so the factual record as it was before the trial court on cross motion for summary judgment, did it include any factual assertions about any residual ownership of the property by Rosetta's estate, or any factual disputes to clarify or call into question that it was not a transfer through intestacy of a tenancy by the entirety? Did I say that right?
Yes. Well, what was filed after the court granted the appellant an extension of time, what they filed, which again I believe might have been late, was captioned a preliminary opposition to the motion, which announced it was a first step to opposing the motion, and that they would supplement it with additional material as soon as possible. The opposition that was filed failed to respond to the allegations in our motion in any meaningful way. The opposition made no attempt to address the equitable estoppel argument or the laches argument, failed to cite any facts in the record. So while they made arguments that, well, the ones to blame were the settlement companies that missed this, that was sort of the argument that was made. There were no facts cited to in the record.
Okay, so the miss this, the this being that there was in fact any residual title or ownership of the property that did not pass through the intestacy process with respect to Rosetta's estate, because she did not have a will, correct?
My understanding is Rosetta did not have a will, but Edward did.
Right. So when she died, the property, her interest in this property on Drake Street passed in full, whatever it was, to her husband at the time, who who she predeceased, correct?
Well, that was sort of the dispute. We believe, because the deed was not really the best worded deed in the world, but it said that they were husband and wife. And I think there's a presumption, according to the case law, that property that's held as husband and wife is owned as tenants by the entirety. So the appellant and the appellant's sister, who was the personal representative of Edward's estate, both made the assumptions at the time the estates were handled that the property was fully owned by Edward's estate because Rosetta had predeceased.
And so the arguments that we're hearing about potential, I guess, third-party ownership or partial ownership, that it may have included someone else along with Rosetta before it passed in testacy, is that part of the facts that were considered in conjunction with the summary judgment motion?
Your Honor, I think you might be confusing two things that were in the record.
Yes.
There were a series of properties next door to each other that both Edward and Rosetta had an interest in.
Right. But
One
I'm
of the
talking about the property in dispute now.
So the property in dispute now, there was only two people were on the deed, was Rosetta and Edward. There was another property, which Your Honor just might have referred to, that was also owned by the daughter. And so when Edward, the appellant here, Edward's son, the appellant, when he was the personal representative of his mother's estate, that estate was opened in the state of Maryland. He then filed an ancillary estate in the District of Columbia to claim an interest in the property next door. That was also owned by his father and his sister.
So the property at issue here, just so I'm clear here, is there any evidence disputing that it rightfully passed wholly, fully, and what is the property term, to Edward Sr. upon Rosetta's death through her intestate estate?
Sure. I think that was sort of the initial dispute, which is why we filed the complaint to begin with, to clear up that question. The motion for summary judgment that we filed that was granted, however, didn't even take that into consideration, because obviously the property is fully owned right now by Mr. Carrasco if there's no question that Rosetta's interest passed 100% to her husband at the time of her death. Our argument on summary judgment was, let's not worry about that dispute, whether or not they owned it as tenants by the entirety or tenants in common. Regardless, the appellant, who was the personal representative, he had a legal obligation as a personal representative to locate, take possession of, and control all of Rosetta's property. That he knew, or at the very least, should have known, that Rosetta had an interest in the property. And we cited to several items in the record with that knowledge. Then, during the 7 years that his father's estate remained open, the appellant and his attorney received a number of requests to sell the property that were filed with the court, along with appraisals indicating that perhaps Rosetta had an interest. And he also received a number of accountings that were filed with the court that claimed that his father owned the entire undivided interest in the property. All of these were filed without objection from the appellant. My colleague on the other side just said, well, if we had known, the appellant Edward would have objected to the sales price. Well, Edward had every opportunity to object to the sales price. There were 3 separate motions with the court to sell the property. Initially, it was valued at around $150,000. Then there was a fire that greatly damaged the property. The personal representative of Edward's estate then received a second appraisal because of the fire damage. The property then sat on the market without any offers until there was an offer to purchase it for $60,000 in 2011. So the appellant had several opportunities if you wanted to object to the sales price, and you didn't do it.
Mr. Bernstein, as I understand it, Rosetta really has two estates, or there's the main estate in Maryland, and then there's an ancillary or auxiliary estate here in DC. Do you know if her estate is still open?
Your Honor, I think the estate was closed. I think the only issue there was selling the property next door, which I believe was done, but I'm not sure. I know Edward's estate was open for 7 years before the property was sold. So over that 7-year period, there was no objection from the appellant that, his mother's estate had an interest in the property. There was no objection to all the pleadings that were filed by his sister claiming that his father owned 100%.
And focusing again on Rosetta's estate, has her representative ever made a claim to this property in Maryland?
No, Your Honor. My understanding, and I think it's part of the record, when the estate was open in Maryland, there was no identification of this property in Maryland, nor was there an identification of the property at interest here when he opened the ancillary estate in the District of Columbia.
Okay. You were about to tell us 3 independent reasons, and we sidetracked you at the end of one.
Sure.
I think you were about to talk about latches.
Correct, Your Honor. So with
And
latches,
let me stop you again.
sure.
Is latches really independent of the first reason you gave, no disputed facts? Or does the factual record lead to the legal conclusion that Mr. Holloway was guilty of latches?
The trial court identified it as a separate reason, but I think there is a two-pronged approach when you fail to address the factual assertions. Even though there was a failure to address the factual assertions, the court still needs to find, based on the facts that are undisputed, that we're entitled to judgment in our favor. And so the reasons we are entitled to judgment on our favor was based on both latches and estoppel. So it's, sort of the same thing.
And so Mr. Holloway didn't know. So how can he be guilty of latches?
Well, he did know. He did know, and that was cited to in the record that several times, which we cite to in our brief on pages 27 and 20. We cite to our record in our brief on pages 6 and 7. But Your Honor earlier mentioned whether it has to be actual knowledge for latches to apply. And that is not the standard in the District of Columbia. Constructive knowledge suffices to establish latches. And I'm citing the case of verse Welch, where, and I'm quoting, the rule does not require actual knowledge to sustain the defense of latches. Means of knowledge is equivalent to actual knowledge. And so while the undisputed facts in the record state and establish that Mr. Holloway had actual knowledge, the standard for latches to apply, you don't even have to get to actual knowledge. You can get to constructive knowledge, and not even constructive knowledge, but just a means of knowledge. And clearly Mr. Holloway and his attorney had the means of knowledge and had, at the very minimum, as the trial court indicated, constructive knowledge.
What's your third point?
Certainly, and just the last thing with latches, and I don't think there's any dispute or argument about whether my clients would be prejudiced by the delay in asserting a claim against the property. My client financed the purchase of the property with a loan that's now held by Wells Fargo. My client made many improvements costing $40,000. The client's been paying the taxes for the last several years. And again, there's no dispute regarding those facts, even on appeal. Finally, the trial court entered judgment in favor of Mr. Carrasco and Wells Fargo Bank because appellant's claim to the property was barred by the doctrine of equitable estoppel. Equitable estoppel is the effect of voluntary conduct of a party where he is absolutely precluded from asserting rights which might perhaps have otherwise existed. So under the doctrine of estoppel, a party who accepts the benefits of a transaction may not subsequently turn around 7 years later and say, oh, wait a second, I still have a 1/2 interest in the property that was sold. When the property, the entire property, was sold in 2011, the appellant received the proceeds from that sale. So because the appellant accepted the benefits of that sale without objection and with the approval of the court, estoppel now bars him from asserting that, wait a second, Rosetta had a 1/2 interest all along. In his brief, appellant only argues that, well, not all of the heirs of Rosetta's estate received the proceeds from the sale. There are two problems with that argument. First, it wasn't raised at the trial court and certainly shouldn't be considered for the first time on appeal. More importantly, the appellant was the personal representative of the estate for Rosetta, and he received the proceeds from the sale. His sister, Daniela, who I guess wasn't an heir of of Rosetta, but was not an heir of Rosetta. She's not a party to this case. She's not a party to this appeal. She's never made any claim to the property. It's the appellant here who's now trying, because of the improvements that have been made to this property and the increase in the value, he's seeking now to avoid basically the effects of the sale when he received and retained the proceeds from the sale. So for all of those reasons, the trial court did not err in concluding that the appellant was stopped from asserting a claim against the property, and the decision of the trial court should be affirmed. Thank you.
All right, thank you, Mr. Bernstein. Mr. Merkel, I will give you a couple minutes for rebuttal.
Thank you. I'm going to ask the court to refresh its recollection, page 526, 567 of the affidavit of Edward Holloway filed in support of his motion for summary judgment, in which he clearly stated that his parents were not married because his father was still married to Lucille Holloway. So there was no intestacy of his mother's estate passing to his father, whether certainly not a tenancy by the entirety, since it wasn't specified in the 1968 deed, and nor by operation of law. Had no familial relationship with him, although they were parents of a couple of children together. So that I think that's very significant. To the extent that his affidavit contradicts statements in the statement of facts propounded by the plaintiffs, I think the affidavit has to carry the weight. As far as the question of the notice, I think the fact that even the title company in this case, and nobody is talking about this deed being no good. It is essentially a quitclaim deed on the part of the estate of Eddie Holloway. It is not a deed that conveys the entire fee correctly, because even by its own terms, it doesn't state how Eddie Holloway acquired the fee interest in the land. It just states that he acquired it by his deed of 1968, where he obtained it with his wife, his alleged wife. Well, Mr. Holloway identified why they were identifying themselves as husband and wife socially, but that they never were legally married in his affidavit. No, it's a little bit confusing. I know that there's a lot of finger pointing that people would like to give back to Edward Holloway and say, hey, you had 2.5 years of college. You should have understood all this stuff. Lawyers don't understand this stuff. Judges don't understand this stuff. This is an arcane, nuanced area of law. Reading deeds and understanding them right off the bat doesn't jump out to practitioners. If there was an attempt to sue Eli Gitterman for malpractice, it would have failed right out of the gate for him supposedly failing to understand that Rosetta Holloway had an interest that survived the death of Eddie Holloway. So the idea that I admit it. Getting old's a bitch. And in 2019, I had atrial fibrillation diagnosed, and it sidelined me a lot that year. Kind of rebounded back in 2020. And anyway, we don't like to talk about that stuff, but it's true. I think at one point in this case, I did mention to the judge that I was on a greatly reduced workload and had to, ration my time for my practice accordingly. But that doesn't change the facts. And it doesn't change the fundamental fairness that Carrasco is relying on the deeds before him, which have been blessed by title attorneys employed by Fidelity. And they are basically glossing over the illegitimacy of that 2012 deed. And the plaintiffs the plaintiffs in this case have never held that 2012 deed up and said, look at this, this is great, because they know they can't. And so they want to say it was a tenancy by the entireties. And then they know they can't do that. Then they want to say, well, they were married and so she inherited by intestacy. But they know they can't do that. In the documents that they submitted from Maryland, it clearly states Rosetta Holloway was not married at the time of her death. I believe that the affidavit that was filed in support of Mr. Holloway's motion for summary judgment, which is based on the deed and lack of notice, contradicts sufficiently the items that the plaintiff is relying on to advance, and that the court is relying on to advance the doctrine of laches in this case. Thank you.
All right, thank you. We thank both counsel for your briefs and arguments, and the case is taken under advisement. And you can be free to exit our virtual courtroom at this time. We have one additional matter remaining.
Thank you for your attention, and I'm glad to have been part of the last virtual, hopefully the last virtual courtroom for your honors as we go forward out of the post-COVID stage in September.
All right, thank you, counsel. Right. Good afternoon, counsel. Or I guess we've got maybe just a couple of minutes before we technically reach noon. This is the third matter on our calendar for the day, in the matter of In re Rashawn Gaskins. Are parties ready to proceed?
Yes, Your Honor.
All right. Please proceed, Ms. Pembroke.
Thank you, Your Honor. My name is Christine Pembroke. I'm here representing appellant Rashawn Gaskins. To protect Mr. Gaskins' constitutional liberty.
Sorry to interrupt you, Ms. Pembroke. I just wanted to verify whether you wanted to reserve a couple of minutes of your time.
Yes, just 2 minutes, Your Honor.
All right, thank you.
To protect Mr. Gaskins' constitutional liberty interest, the Urban Act and due process impose several requirements. First, there had to have been a showing that Mr. Gaskins was likely to injure himself or others. Second, there had to have been a showing based on Mr. Gaskins' current condition at the time of trial that such risk of injury was present. Third, the likelihood of injury could not have been based on conclusory evidence, and along those same lines had to be based on clear and convincing evidence. And
Ms.
finally,
Pembroke, I'm sorry, if I could just interject to go to the first element that you referenced about the likelihood of injury to himself or to others. How we've interpreted injury is pretty expansive, right? It's not necessarily just limited to a technical physical injury. It is more expansive than that. Would you agree with that based on some of our prior case law?
I would agree with that, Your Honor, but I would also argue that the prior case law doesn't really address a situation in which the injury results from the inability of others to respond appropriately to speech. And it talks about that the case law is more along the lines of what kinds of injury are not covered, such as injury to reputation.
Right.
I think in this case, even assuming Mr. Gaskins approached people other than trained law enforcement officials who seem to be able to react appropriately to behavior, the fact that others might not react appropriately is not a valid reason for constraining his liberty interests.
Right. Well, we have sort of an interesting situation here because I guess on the one hand, we're not just talking about speech. We're talking about threats that he made on numerous occasions, coupled with a diagnosis, a serious mental health diagnosis, indicating that he was fixated and with ideations that prompted him to make some of these threatening comments about at the White House to Secret Service agents and at the Capitol to the Capitol Police, including threatening to bring a gun, threatening to commit violent acts. So we have more than mere speech, but we also, as you said, have a situation where part of what's being argued, it's not the grounds that I understand the trial judge ruled on, but one of the arguments here is that because of Mr. Gaskins' odd and threatening speech and comments at public places involving government officials and members of the public, that police force might injure him, and his behavior might cause them to injure him because they would be trying to restrain him, not realizing he had mental health issues. That's sort of how I understand one of the arguments. I don't understand that to be the grounds upon which the trial judge ruled here. Could you clarify that for me?
Right. I believe that the government raised that argument on appeal, and they cited an article about the frequency with which mentally ill individuals are injured by police. And I think that is really an erroneous approach to the law. The Urban Act has to be applied narrowly. And the fact that police respond inappropriately to people who are unwell should not be a reason for constraining their liberty. It should be a reason for training the police to deal properly with individuals with mental health issues. So, I would hope that this court would not consider that alternative grounds for perhaps upholding the trial judge's decision.
And so the trial judge's decision itself, tell us why the grounds on which the trial judge based his decision are not sufficient for us to uphold that and affirm it on appeal.
I think first and foremost, Your Honor, the trial judge was not basing his decision on Mr. Gaskins' current mental health state at the time of trial. Dr. Shustakov testified about the risk of injury that Mr. Gaskins' condition presented based on when he had first been committed in August. At best, just Dr. Shustakov basing his evaluation on when he last saw Mr. Gaskins, which was at the end of September, and the trial was months later. In that interim period, Mr. Gaskins had approached Capitol Hill Police and been able to control his speech and not gone into issues that had gotten him into trouble before. He sat through multiple days of trial and behaved appropriately and didn't interject any comments that were cause for concern. And when he was on the stand, he seemed to appreciate the line that he could not cross, and he explained the reasons for his comments in ways that were not necessarily threatening to other individuals. He explained his comment to Officer Trotman, for example, that I don't know how much money you make, but I'm coming for you, or something to that effect, as an indication that he planned to pursue a civil suit against Officer Trotman, not that he intended any kind of a physical violence to him. So I think based on
What were the factors, as you understand them, that the trial judge relied on that you feel were erroneous? As I understood it, he relied on Dr. Shustakov's diagnosis of Mr. Gaskin's mental health condition. He relied on the serious nature of the threats, including the threats made after some of his initial court appearances. And so I may be missing a few things. If you could refresh my recollection and then tell me why what he relied on was not sufficient or clear and convincing evidence.
I think that that's correct, Your Honor. He relied on all those facts, the testimony from each of the officers about.
And the fact that he wasn't taking his medication.
Yes, that's true, Your Honor. He did not seem to rely on anything that Mr. Gaskin said at trial. He seemed to focus on just the government's witnesses and the fact that he wasn't taking his medication and not following through. And I think that was not adequate because it was all not supported by what he was doing in the last few months before trial. And if the judge had felt that he needed to have more information about Mr. Gaskin's current condition, then he should have ordered that rather than just relying on stale information about his condition.
So help clarify, Ms. Pembroke, what standard of review do we apply when assessing the trial judge's ruling?
I don't think that there's a lot of case law on this, but I believe that the standard would have to be that you'd have to pay deference to the trial judge's factual findings. And
isn't a finding of future dangerousness really a factual finding? It's predictive, but it's factual in nature.
It's primarily, yeah, I would have to say that it's factual, Your Honor. I can't really see how there isn't much in terms of legal criteria that apply to that other than what, harm means. And in this case, I don't think the judge was basing his decision necessarily on illegal understanding of what dangerousness means. I do think that the judge did not take into consideration the fact that Mr. Gaskins was controlling his behavior and didn't really address that issue. But I do think that this court has to pay deference to his factual findings.
You talk about current condition, which leads me to ask, unfortunately, a lot of time has passed since this trial occurred. Has anything happened to Mr. Gaskins that bears upon the decision we have to make? For instance, has he since been committed in new proceedings?
Your Honor, I can't say with 100% certainty what Mr. Gaskin's status is, but it is my understanding that he has a misdemeanor matter pending against him in the Superior Court and that he's being held in Maryland. But I don't know what the basis for the hold on him is in Maryland. And of course, his year commitment under, in this case, has expired. I think that expired back in December.
Thank you.
I wanted to ask too about your focus on his current condition, and you may need to correct my understanding of the facts here, but the commitment in question is outpatient commitment, correct?
That's correct, Your Honor, but it's
Outpatient commitment. And here's what I want to ask you. So when you point to your client's demeanor and conduct, appropriate conduct during the trial and his testimony, I'm assuming that that was all given and shown during a period when he had been committed already, because as I recall, he had initially consented to it and then withdrew his consent. So where I'm going with this is, if his demeanor and the appropriateness of his statements was a reflection of his adherence to his medication regimen at that time, how does that impact the court's need to look at his current condition? Is it's a current condition that is corrected, so to speak, by his medications? Help me understand that, please.
right. Well, Your Honor, as far as I know, he was not taking his medication at the time of trial, but I can't say that for certain. And part of the reason for, my inability to comment on that is that there was no testimony taken at trial as to what he was doing to be compliant with his commitment conditions in the months after his release on September 26th. So I really couldn't say whether or not, in fact, his controlling his behavior was a result of the conditions of his commitment, or just because he began to learn through his various encounters with law enforcement what was appropriate behavior and what was not, and knew how to refrain from engaging in conduct that was going to be injurious to himself. So there was no testimony on that. And as far as I know, there were concerns about his complying. The trial judge indicated that he'd not been going to meetings that he was supposed to be attending. So it appears that the treatment that he was supposed to comply with was not the reason for his conforming his behavior. And I think one of the other concerns with this case that we have is that the trial judge noted that Mr. Gaskins was sort of compulsive about his behavior, but his behavior involved approaching law enforcement officials who all seemed to understand how to deal with him and were not acting in a way that was injurious to him. If anything, they were acting in a way that may have been helpful to him in making sure that he was getting his treatment. So even though, if you accept the trial court's findings as true, that Mr. Gaskins was fixated on approaching certain law enforcement officials, that conduct was not a reason for restricting his liberty, because it was not resulting in any harm to him. So I think for all those reasons, we would argue that the order of commitment for Mr. Gaskins should be found erroneous and vacated.
Is this matter moot, perhaps, since his commitment has expired?
So the government in its initial brief pointed out that the fact that the commitment period would expire was not a reason for finding that the case is moot, and they cited authorities there, and there are a couple of cases in which this court has held that the collateral consequences of a commitment order are such that it would not be moot even though the period of commitment has expired. And I think that in Mr. Gaskin's case, that's particularly telling, because obviously if he has ongoing mental health issues and is back in the system again, the fact that there was a finding that he needed to be committed on an outpatient basis is something that would influence future decisions about his treatment, just as in this case, the mental health officials in the court look back to his previous history with the mental health system.
All right, thank you. All right, we'll reserve a few minutes for your rebuttal time. And at this time, we'd like to hear from the District of Columbia, Ms. Johnson.
Good morning. May it please the court. I have 4 key points that I would like to address that I think will address the court's questions thus far and sort of crystallize what's going on in this case. The first involves whether, if repeated, this conduct is likely to lead to injury. And I do want to address what the Superior Court held, because my understanding of the Superior Court's ruling was that he did indeed find that Mr. Gaskins his conduct could lead to injury to himself. And I would point this court to page 206 of the supplemental appendix, where the court praised the officers for the degree of professionalism and control they showed and indicated that other officers may not have shown that level of control. Now, I'm not suggesting that this means that an officer showing a little bit less control would have necessarily been violating Mr. Gaskins's rights, but going to the White House and saying, if you don't stop me, I'm going to start hurting people, or I want to start killing people here, is illegal. It's a threat. And the officers could just as easily, instead of calling CPEP, have called the police and had him arrested. And this court has held that an arrest or conduct that can lead to an arrest or prosecution or any sort of criminal action is a per se injury. This case is not in my brief, so I'm going to give you the full site. It's United States v. Charnazon, and the site is 232 Atlantic 2nd, 586. It's in a different procedural posture, but the test there is the same, the factual test, whether the individual was dangerous to himself or others in the reasonable future. And in that case, this court held it is enough if there is competent evidence that he may commit any criminal act, for such act will injure others and will expose the person to arrest, trial, and conviction. In that case, the individual was floating bad checks. It wasn't even a threat to do harm. And yet this
Ms.
court—
Johnson, can I add on this point, when I believe Judge Fisher asked the question earlier during Ms. Pembroke's argument, but when do we move from speculation or from evidence determinations, credibility determinations, factual determinations, which the trial court is required to make in these kinds of cases about dangerousness and likelihood of injury to self and others, to the realm of speculation?
So
and here, why are we able to conclude, in your view, that the trial court found by clear and convincing evidence, not mere speculation, that Mr. Gaskins was likely to injure himself or others?
I'm glad you asked that, because that was in fact my fourth point. I wanted to discuss that. Each of these cases is unique, and that's one of the things this court has recognized. You're not going to find another case where someone is going to public buildings and threatening to kill people. You're not. All of these cases involve, because mental illness portrays itself in so many unique ways. So what this court has done, and Peruso is where you find the test and the indication of how this court has handled it, is it has deliberately declined to over-define the term injure, instead trusting the trial court to make the proper judgment. So the standard of review is deferring to the fact finder's weighing of evidence. This is in Peruso, deferring to the credibility determinations, and making all justifiable inferences in favor of the government. Beyond that, in Peruso, this court explicitly said it will not overturn such a finding or such a ruling unless it is plainly wrong or without evidentiary support. So what this court has acknowledged is there's going to be a judgment call. There's going to be a judgment call as to whether something is likely to recur, and there's going to be a judgment call as to whether that is sufficiently dangerous to warrant a deprivation of liberty. But this court has placed that judgment with the trial court, not on appeal. The trial court applies the clear and convincing evidence standard. This court applies a sufficiency of the evidence standard. So when and there's a reason for this that makes a lot of sense. You can look at, for example, what Mr. Gaskins said to Officer Troutman outside of the courtroom. I don't know how much money you make, but I'm coming for you. We're reading a cold transcript. So we can look at it and we can read the brief and say, oh, well, maybe Mr. Gaskins meant something benign. But Troutman was threatened by this, and he was concerned about this, and his coworkers were concerned about this, and the trial judge was the person who witnessed that testimony. The trial judge is the one that saw the demeanor. And so if I can just quickly go through the most critical evidence of dangerousness, which is shorthand for this likely to cause injury in the future, dangerousness, there's plenty of factual evidence that is not speculative. Before I go through that evidence, though, I want to highlight one other case, which is Stokes, which is where this court was saying that evidence was too speculative to satisfy the clear and convincing standard. And in that case, this court reversed because there was only vague conclusory hearsay evidence by the expert instead of lay testimony about the behavior itself. Here, what was missing in Stokes was exactly what was provided here. The testimony of officers who witnessed Mr. Gaskins' behavior and testified as to what they saw and how they perceived it at the time. So I'm just going to briefly walk you through that. Let's start with the White House incident. Officer McCarthy said that apologize, that Mr. Gaskins approached him and asked if the area was secure, and then said, and I quote, that he wanted to start killing people here. McCarthy testified that it seemed to him that Mr. Gaskins actually had the intent of wanting to hurt other people, even himself. So that is the testimony of the person who witnessed that, and the trial judge is the one who got to witness that demeanor. And Mr. Gaskins, while he denies having said that, he says that he told Officer McCarthy, if people are willing to threaten my life, then I have to defend my life. And this is a theme that runs throughout his testimony, even at trial. His testimony at trial, this theme that his life is being threatened, that he is being assaulted, and that he needs to do things to defend himself that might involve harming other people. So the next incident was the Capitol building incident, and where he, just having a conversation about the ills of the world, he told Officer Troutman that, maybe the way he would fix things is to return armed when Congress is in session. And he gestured like he was pulling a handgun out of his hip. Now, again, we weren't there to witness Mr. Troutman's testimony, or Officer Troutman's testimony, but the trial judge was. And Officer Troutman testified that he interpreted this as a specific threat that made Mr. Gaskins dangerous to others. And that is at page 55 of the supplemental appendix. Then after that, we have Mr. Gaskins threatening Officer Troutman after trial. And the trial court found that this was dangerous. He said the threat to Troutman was some scary stuff. And if it had been made to a civilian or a prosecutor, it could have led to a threats charge, like a criminal charge, again, which is per se injurious. Then after that, Mr. Gaskins returns to Officer Troutman's post months later to find him. Again, the officers who are experts in threat assessment found this worrisome. They found it dangerous and they were concerned. So certainly we cannot look at this transcript and say there's no evidence or without evidentiary support of a finding that dangerous events happen. So the second point that I wanted to make is the argument that Mr. Gaskins is making, which is that he was better by trial. And so there are two things I'd like to highlight in response to this. First of all, that's not how bipolar disorder works. And I think you can read this, first of all, from a common understanding, and as the judges can bring their own knowledge into the courtroom, but also from Dr. Shustakov's testimony that bipolar disorder is marked by episodes of mania and episodes of depression, or perhaps one or just the other. So regardless of whether Mr. Gaskins was entirely lucid at trial, and I will dispute that next, but regardless of that, this does not indicate he will not have another manic episode. And in fact, Dr. Shustakov testified that there was a high risk that if Mr. Gaskins' condition was left untreated, he would engage in similar behaviors. That is certainly sufficient for the judge to find that these episodes were likely to recur.
Ms. Johnson,
yes.
on this point, or slightly tangential to this point, I was surprised that I don't think either side's brief makes much about Dr. Shustakov's testimony that Mr. Gaskins had actually had an aggressive, agitated episode while he was at the Psychiatric Institute of Washington, during which aides had to be called and he had to be restrained. That testimony was before the trial judge as part of all that he considered, although I don't think he specifically referenced it either.
Your Honor, you're correct. And I probably should have highlighted that in my brief. It's certainly part of the whole mosaic. I think that it also goes to his unamenability to treatment and his refusal to even have any kind of interaction with a mental health professional. But yes, and I would also say that the trial court got to hear Mr. Gaskins testify about a physical altercation with marshals at the courthouse. And so Mr. Gaskins says that the trial court did not credit that as true, but it means one of two things. It means either that actually happened or some version of that happened. It doesn't have to have played out exactly the way Mr. Gaskins recalled, but either he actually got into a physical altercation with US Marshals, which is an indication of injury to self or others, or he believes he got into an altercation with US Marshals at the courthouse. And again, he keeps testifying to the need to defend himself. And if this court can bear with me, I want to point out what he did testify it to at trial, because I don't think that the judge was required to find that he was fine by trial and had learned to control his comments, or had maybe no longer had the ideas of harming other people. At page 169 of the supplemental appendix, this is the very end of direct examination. And this is during a colloquy or a discussion regarding why he did not want to be committed as an outpatient. And I'm not going to read his whole paragraph because he does tend to ramble. But towards the end of his paragraph, he said, I have a bunch of ideas. And if I am able to get the personnel and equipment to manifest my ideas into reality, then guess what? I want to do that. That would be my treatment. And the question, do any of your ideas involve harming people? He says no, but then he qualifies that. And I quote, under Title 10 of the United States Codes, United States Armed Forces, when it comes to military operations, you need certain permission to do things militarily. I get that. So then on the next page, Supplemental Appendix 170, they start cross-examination and they kind of follow the same theme. And the question is regarding to whether the officers lied when they said that he threatened to harm people. Here's the question. But the officers who made those statements that you wanted to kill people, and here's Mr. Gaskins' response, and I'm going to read it to you verbatim, even though it's a little jumbled, because I think it's important. His response to the question, when the officers made the statements you wanted to kill people, I am saying that this, and I said I wanted to defend myself. And if that means doing those things, that is what would be necessary. He was just asked about making statements about wanting to kill people. And he said, and if that means doing those things, that is what would be necessary. So there's certainly evidence that either he actually wanted to harm people, which is one of the things the Superior Court was concerned about, or he was certainly not controlling himself by discussing wanting to harm people. So I don't think it's fair to say that he was better by trial or that there was insufficient evidence. I do think the Superior Court left it open as to whether his injury would be to himself or whether the injury would be to other people. It is well settled that if someone puts themselves in a position where they're likely to be harmed by other people because of their behavior, that qualifies as likely to injure self or others. That comes up a lot in the emergency hospitalization cases.
Is this a new theory, as Ms. Pembroke suggests, that the government is offering?
Not at all.
Do we have a prior case where the conclusion was that someone was a threat to injure themselves or others because of how someone else might react to that person's behavior, like law enforcement?
Yes, and not law enforcement in particular. It's Peruso. I will note this court doesn't have a lot of published opinions on the facts. So a lot of this is just sort of, especially not on the clear and convincing evidence standard. But Peruso is close enough that I think it gives this court a really good sense of how this is supposed to work. In Peruso, the plaintiff, or Ms. Peruso, the individual in question, was leaving her apartment at night, in the middle of the night, and knocking on her neighbors' doors because she thought they were spying on her. And so the risk to injury was not that she was going to injure her neighbors, although perhaps that was part of the risk, but the risk was that somebody would react badly to that and injure her. And so I think that's the clearest case on this, but it is well understood throughout all of the numerous unpublished decisions by this court, and cases involving involuntary medication. There's lots of cases involving a dangerousness standard that if someone is engaging in behavior that is likely to create a negative reaction from someone else and make them hurt the individual in question, that qualifies as likely to injure self or others.
So would we be affirming, are you suggesting that this would be an affirmance on an alternative ground than that of the trial judge, or the same basis upon which the trial judge ruled?
I believe it would be the same. I think the trial judge ruled on both grounds. The trial judge found that other officers might not have shown that level of control. I think that we as humans with our own common sense understand that someone could get hurt if they go to the White House and say they want to start killing people. Someone can get hurt if they say they might jump the White House fence if they feel like they're in danger. Someone could get hurt if they say they're going to return armed when Congress is in session. But also, the Superior Court was also concerned that Mr. Gaskins might injure other people. He talked about him being locked into certain things, and those things involve doing harm to others. That's page 210. The district is supporting both grounds. I don't think they need to be parsed out. This court has never required that level of specificity from the trial court, but this would just be a straight affirmance on the grounds relied upon by the trial court.
Thank you.
Ms. Johnson, I asked Ms. Pembroke if anything has happened to her client since this trial that we ought to know about. Do you have anything to add to the information she provided?
I don't. Once his commitment expired, I don't have anything new about him. I would agree with Ms. Pembroke's statement that this case is not moot. He has an interest in having it resolved, even though he is no longer committed.
Thank you.
Thank you. Ms. Pembroke, I believe we reserved about 2 minutes rebuttal time for you.
You're on mute, Ms. Pembroke.
I'm sorry. I'd like to address the government's reliance on the case of Charnazon. That was an appeal by the United States from a court order granting unconditional release under the NGI to an NGI equity. And the order was vacated and remanded. Charnazon was found not guilty by reason of insanity, and the court's analysis applied to the decision whether Charnazon had met the burden of showing that he was entitled to an unconditional release under the provisions of the statute governing not guilty by reason of insanity release. So it doesn't deal at all with the mental health detention statutes and commitment cases that are relevant here. I'd also like to address quickly the case of Peruzio, which the government has relied on. And as the government notes, this court has emphasized that each case is sort of decided on a case-by-case basis. And I would argue that the kind of conduct that was going on in Peruzio, where the respondent was going to all of her neighbors in the middle of the night and knocking on their doors and accusing them of spying on her, clearly created a risk of injury to her. Whereas in this case, the facts are very different. Mr. Gaskins has only, and as the trial court noted, sort of fixated on police officials who seem to understand how to deal with him. They've never reacted in a way that was harmful to him. They've reacted in a way that was helpful to him. And by the time of trial, he had been able to control his speech. And although the government has focused on the fact that bipolar disease is episodic, we have a prolonged period between his misbehavior in late August and his subsequent conduct in which he had not engaged in any kind of actions which were injurious to him. And I would argue that although he is still espousing some of his theories that were troublesome, they were not at the level that would cause a person to injure him because of his beliefs, because he was qualifying what he was saying. He was appreciating that he couldn't just make statements like, I'm just going to go harm people. He was explaining what might induce him to take action that might cause him, it was all conditional conversation, qualified conversation. And I think that's the sort of understanding of his condition by himself, as evidenced by him, that he couldn't cross a line. He needed to be careful about what he said. And he was doing that by the time of trial. So I don't think I have anything else unless the court has some further questions. I would just reiterate that we would ask that the order of commitment be vacated and that the court find in favor of Mr. Gaskins.
All right, thank you, Ms. Pembroke and Ms. Johnson. I'd like to thank both counsel for your briefs and arguments today. And we will take the matter under advisement and appreciate your time with us this afternoon.
Thank you, Your Honor.
This court is now adjourned.
All right.